May it please your lordship. Matter seeking the lordship in Indians matter with respect to item number 30, 30 matter. In this case, I have also informed the other side matter. I pray for 2 weeks time matter.
Okay. Mr. Amit Rajborvia, Learned Counsel for the petitioner has sought adjournment in the case for 2 weeks. It is submitted that concern has taken from the Learned Counsel for the respondents to make the prayer. The prayer is allowed, is the case submission. 2 weeks on it.
May I please, your lordship? Lordship, I pray for listing of 2 writ petitions, your lordship.
Yes.
Listing of 2 writ petition admission column, your lordship, whereby interim order was passed regarding the settlement of Mohol, your lordship. So may I pray
Okay. Next week.
next week on any date, your lordship?
Next week in
Yeah, lordship, yesterday your lordship had allowed listing of a motion today, but it has not been listed. The case is already numbered. Lordship, can it be listed today, lordship?
Okay.
Problem.
May it please your lordship, my lord, with regard to item number 48, my lord. If your lordship recollects, my lord, that lordship had heard the matter, Mr. K. N. Chaudhary had advanced his arguments, my lord. But may I, there is a stay order operating against us, my lord. May I pray that after the motions, if it is possible, my lord, or at 2 o'clock, my lord.
We will see.
My lord.
We'll see. We'll try to accommodate you.
My lord.
May I please, Lord, I beg to mention item number 43, 44, and 45 matter. 43, 44, 45.
Yes.
My lord, in this case, we have received instruction, my lord, 4 weeks time may be granted to file actually.
43, 44. Let us wait. What is there?
Lordship, here is for same, your lordship. I have taken consent from senior advocate, your lordship, T.
Which one item?
43, 44, 45. I am for the respondent.
Oh, your finance. Why?
Tender matter, your lordship. Settlement of Mahal, your lordship. Interim has.
Okay, these are for SR. Wait for your turn. We do not pass order on SR at the motion stage.
May I please, my lord? Now, item number 22, my lord. The matter has become infructuous, my lord. I have instruction to withdraw the matter.
Item number 22. Okay, Mr.
B. Das, my lord, on behalf of the
Vidas, Learned Counsel appearing for Mr. L.K. Bora, Learned Counsel for the petition has submitted that the subject matter of the writ petition has become infructuous and therefore the petitioner wants to withdraw the writ petition. MS Mr.
R.B. Goswami, my lord.
R.D. Goswami, Learned Counsel for the Respondent Transport Department.
On behalf of
Is in attendance. In view of the above submission made by so and so, the writ petition is dismissed as infructuous.
all my seniors, they may be recorded.
No, not present.
May please, lordship, item number 3. Item number 3.
3.
May kindly be adjourned for that day because the engaged counsel is out of station.
Okay, on the prayer of
M. Rahman.
what is this case? M. Rahman. You be there, we'll issue notice.
Yeah, please, your lordship. Lordship, yesterday we have filed one affidavit in respect of justice service to the private respondent. Lordship may be allowed to call for the record of his name. I'm obliged.
Please, your lordship. WPC 359 of the 23. Lordship, I pray to mention for listing of the matter on Monday.
Monday,
Yes, Lord.
motion.
Motion.
Motion. New matter.
No, Lord. On the last date, the Honorable Court has issued notice of motion.
Then admission, it will come in admission.
Interim prayer.
Next, not this, next week, next to next week. Yes.
Lordship, also I want to mention WPC number 2732 public 23 for listing of the matter. This matter, lordship, here the petitioner, husband of the petitioner was killed in an elephant attack, and this matter was last listed in 1923.
Bench 5. Bench 5. You make a mention before bench.
May I please, the lordship, commission for listing the 2017 matter, lordship.
Subject matter.
Subject matter, lordship, settlement of landlord.
Bench 5.
Daily list for motion, item number 1.
May you please, your lordship?
Hmm.
Lordship, I have filed an application under section 11 of the Arbitration and Conciliations Act. Lordship, notice may be issued against the sole respondent. Lordship, there is an arbitration agreement with the between the petitioner and the respondent. In page number 17, Lordship.
This is for managing LPG distributorship.
Yes.
Hmm.
There was a business agreement between the petitioner and the respondent.
Who got the distributorship?
Actually, the
Respondent.
the respondent is the actual owner, but due to some financial hardship, the respondent wanted the petitioner to continue the business.
The agreement appears prima facie is voidable. This agreement is with the knowledge of the Bharat Petroleum Corporation Limited.
Lordship, it is only with the management of the gas agency.
Then everything will go after that. I think this is voidable kind of agreement. Third, Mr.
G. Kaushik.
Z. Kaushik, Learned Counsel for the petition. This is an application under 11 of the Arbitration and Conciliation Act seeking appointment of an arbitrator. Issue notice to the sole respondent. Notice is made returnable in 4 weeks. The petitioner shall take steps for service of notice upon the respondent by registered within 3 working days.
Item number 2.
Obliged.
Who is standing counsel? PWD. Have you brought the contract agreement?
Yes, yes. In fact, I'll just, I'll.
Huh? If it is not before the court, how can?
Well, in fact, at the time of filing, it was not there, but
Because you have said you have executed contract agreement.
exactly. For your lordship's present, I'll just place the relevant so what I'm on, lordship on that last email, I refer to the dispute redressal system. So, how it has to be done, that is there. Firstly, here the case, is that the action is unreasonable and arbitrary. It is in fact violation of the principles of natural justice. Now, lordship,
I'm not doubting about that.
understand.
I'm not doubting unreasonable, arbitrary, all these are there.
The only thing lordship will see the 24 type park, there's a dispute redressal system. If any during the works contract, if anything happens, it has to be referred to the committee. Firstly, lordship, next page is the arbitration clause. In fact, in view of the provisions of section clause 24 of the dispute redressal, it is a condition of the contract that there will be no arbitration for the settlement of any dispute between the parties. So arbitration, it does not apply. Now, lordship on the
Then it will be civil court.
lordship, I'll just the problem is, and the last part, if your lordship sees, the lordship on the first occasion we referred to the termination clauses. Here 52A has been referred, I, J, and N.
I,
A, it is 52A, 52 then I, 52I, J, and N. These are the 411 clauses, which has been referred in the termination order.
Contractual matter, it is available. It is not doubt about that. Question is
Now, Lordship, and there's a
to recall the termination.
No, Lordship, even otherwise, Lordship will kindly come to page 16 of my read petition. What is the prayer? Termination is, my lord, yes, setting aside the termination is one of the prayers, my lord. But first one, my lord, page 16.
Right, Mr. I'm not doubting about your prayer. There is no question about doubting the prayer. From the facts and circumstances you have projected, you may have a good case.
Lordship, well,
I'm not saying that. Question is the prayer first, second, third. Third is dependent on second,
exactly,
right?
Lordship.
Now, if the second is set aside, then third can, it is a consequential act.
In fact, my lord,
But
here,
problem is that it is a non-statutory contract. It is
Understood.
governed by normal law, ordinary laws of contract. Meaning thereby it is under the Contract Act. Right? So relief is for seeking compensation and damage because if suppose there is breach of contract on the part of the department. No, even if you have undertaken some work, but they have arbitrarily terminated it, because otherwise it is both of you have entered into a contractual relationship by volition. Either party can terminate the contract. You can also terminate the contract by giving 1 month notice maybe. Every contract has that clause. Suppose 1 month notice is not there, not given. It is breach. Then breach of contract will give rise to damage and compensation under a Contract Act. Now termination is, if you go by the Specific Relief Act 14 and 41, that specific performance of the contract is not to be exercised by the Reed Code, not even by the Civil Code. Even Civil Code can have, but Reed Code, tell me which code?
Lordship,
ABL Noble Resources, did it say?
yes, my lord. In fact, Lordship, 24, 25, and 27. Mark the
You'll refer to Mahavir, is it not?
or in terms, my lord, ABL.
Mahavir,
ABL,
ABL is regarding money claim. Which one? Tell me which
my
case.
lord, 24 my lord, here ABL has been referred to, my lord. 25 my lord,
Of which case? Noble?
Nobel my lord.
Noble. 24.
Here, my lord, because my lord, I have challenged the, my lord, the arbitrariness of the, my lord, the action, my lord, of the respondent authority. Here, my lord, no opportunity was given to me. This issue a letter, my lord. I immediately, my lord, respond. I undertake to complete the work within the period of 1 year, my lord.
Now,
There is no
what was the case in ABL? It is some statutory thing. Export credit, perhaps. Export Credit Guarantee Corporation. ABL versus Export Credit Guarantee Corporation, perhaps.
Yes,
And that other authority, state, or instrumentality of the state was supposed to perform some statutory obligation, which he did not do. But here is a case, this is under Article 298, maybe in the name of the governor, but still it is an executive action. Mr. Day,
my lordship.
show me any authority that contract has been, after termination, has been revived.
No, question of my lord. Here, my lord, revival is something different, my lord. There is a prayer, no doubt. But at the same time, Now, Lordship will see.
These are to be decided on the basis of evidence, arbitrary, illegal, all these things.
Evidence, my lord, exactly, my lordship. Look, if the my lord action is unreasonable, my lord, the lordship, if that is there, because of the fact, my lord, what I was on the last occasion which I was referring to, my lord, lordship will see. No, my lord,
See, Ram Kripal Jadhav, you have seen, this is essential commodities act,
lordship, but my lord, here,
right?
lots of my lord.
Kosturi Lakshmi, you have shown. What is there? Which order? What
here-
kind of order?
No, in fact, my lord, it has been discussed, my lord, that there is no bar as such, my lord. My lord, when the question of arbitrariness and unreasonableness is there, my lord, the read court has the power to grant relief, my lord. You know, insofar Kasturi Mill is concerned, my lord, lordship, paragraph 14, my lord,
There are, suppose if you see noble resource,
lordship.
right? If you want to refer to noble resource, let me show you a paragraph then. Come to page 15. The paragraph 15.
Lordship.
It is tried. There are two distinctions. One is a distinction indisputably must be made between a matter which is at the threshold of a contract. That is, after NIT is issued, till the award is made. And second part, C, and a breach of contract, whereas and a breach of contract, right? Whereas in the former, meaning by the tender process, the court scrutiny will be more intrusive. In the latter, the court may not ordinarily exercise its discretionary jurisdiction of judicial review unless it is found to be violative of Article 14 of the Constitution. While exercising contractual power also, government bodies may be subjected to judicial review in order to prevent arbitrariness or favoritism of its part. Indisputably, inherent limitations exist, but it would not be correct to find that under no circumstances writ will lie only because it involves a contractual matter. But that is why I am saying that staying the operation is meaning thereby reviving your termination clause, termination of the contract. That is what
The only
pinching the
but
and this NIT is consequent upon the termination.
lordship, what I'm on, my lord, lordship is listening the article.
That is why I have indicated to you that bring the contract agreement, at least we can see. Bring the contract agreement into record.
But that can be done, my lord. Only thing, my lord, lordship will see similar. So for article 14, my lord, unreasonable is a facet of article.
This is discretionary, Mr. They
Understand.
absolutely discretionary, very thin line.
Lordship will kindly appreciate only one thing, my lord.
I'm
Yeah.
appreciating, that is why I'm giving you time. No more time.
No, lordship,
We'll examine at a later point. Relief is always available to you. Every damage can be asked for. But here is a question of termination of contract, maybe in breach of the contract. And for breach of the contract, section 72, 73 is always there of the Contract Act. You seek damage either in arbitration or by civil court. Bridge and roof. So many decisions, I'll just say one. Next, joint plastic,
the only thing, my lord, what is
Korean. All these are state. You want to know? Bridge and roof. Termination of similar contract. Go to arbitration or civil court. Seek damage. Interpretation of the clauses of the contract is outside the purview of the.
that is true, my lord. That is, my lord, that is no dispute. But here, only thing, my lord, lordship will see. Here, the term was one year, my lord. Because of flood, my lord, we could not.
I
That is not the
am
problem.
aware of it.
The only thing, my lord, now they ask for a revised program, my lord. We provide. On the next day, my lord,
That is breach of contract on their part.
no, my lord, that is true, my lord. But at the same time, lordship will see they sought for, they seek for a, my lord, revised program. I submit it on, and then on the very next day, my lord, without any reasoning, that is discarded, my lord.
How can we know that you have done some work just because photograph evidence is not taken into account in a writ petition? You establish everything before the civil court. Seek damage, Mr. Please. I can only issue notice at this stage. I cannot Heard. You are saying that there is no arbitration clause.
No way.
Then it is for civil court to decide. You go through bees and roof, Puri and joint plastic, everything. Everywhere it is said, if it is arbitration is provided, one should go for arbitration, or if arbitration is not provided, then one should go to the civil court.
Then, you know,
Lordship,
with the liberty to,
let the agreement come, Lordship. This is PMG SOI, Lordship. Arbitration is not there, but dispute resolution mechanism is there.
It is, he has shown. He has shown it.
that has also not been adhered to, Milord. Directly, Milord, they reject
You
my,
have to approve.
they terminate, Milord, without even issuing a show cause, Milord.
That is why on
Understand.
two previous days, I had asked for the contract agreement, which you did not provide. I have asked
I understand.
for the contract agreement on two occasions.
Well, initially, it was
Even
not
if I
initially it
was not primarily satisfied, still I gave you time. At least bring the contract agreement on record so that I can see whether it is.
But in my humble
Procedure is
submission,
not
Lordship, sufficient time has been given, Lordship. It's a PMG SOI, Lordship. It's a fixed time program, Lordship. Lordship will see when the letter of acceptance was issued, Lordship. Letter of acceptance was issued on 1st of February, 1st of April, Lordship, 2023. Then on Lordship, page 26, Lordship.
I have seen.
Lordship, at least 3.
Who
notices
is at
have been-
fault? We are not going to decide this. Because your letter of termination is also not properly worded.
No, Lordship, at least Lordship will appreciate the fact that 3 notices were served to him. At
But
least
all
for
were
3
replied.
months, Lordship.
All were replied.
He is also
Waited for 3
replying.
months, Lordship.
Anyway, third, Mr. R.D. Learned counsel for the petitioner, and Mr. P. Nayak, learned standing counsel,
PWD.
PWD, for all the respondents. Full stop.
Lordship may otherwise, Milord, with liberty to approach the civil court, Milord, Lordship, because
Definitely, you can avail every remedy available to you under the law. Will you issue notice?
the Lordship may dispose of that with liberty to approach the any.
No, then I'll dismiss it. If you want withdrawal with the liberty,
Second,
otherwise I am dismissing it. It's not maintainable.
in that case, Milord, withdraw with the liberty.
I am clear.
That is, Milord.
We will not keep it pending.
Withdraw with the liberty to approach the
Okay,
competent authority.
that can be done. Heard Mr. R.D. Learned counsel for the petitioner, and Mr. P. Nayak, learned standing counsel. Public Works Department for all the respondents, full stop. Pursuant to a bidding process initiated by an e-procurement notice dated 14/11/2022, the petitioner was awarded a contract work page 24, upgradation of science society at a contract value of rupees 9 crore 79 lakh 36,949, and a letter of acceptance dated 1/4/2023 was issued to the petitioner. Full stop. It is stated that subsequently, a contract agreement was also executed between the petitioner and the respondent PWD department. Full stop. Pursuant to exchange of communications between the parties, the contract agreement has been terminated by a letter dated 21/8/2023. Full stop. Mr. D. Learned counsel for the petitioner has submitted that the petitioner will not be pressing this writ petition, comma, in order to avail appropriate remedy available to the petitioner under the law. Full stop. Mr. Nayak, Learned Standing Counsel PWD, has not objected to the above submission in view of the above submission made by Mr. T, Learned Counsel for the petitioner. The writ petition is disposed of, is dismissed on withdrawal, comma, reserving the liberty to the petitioner to avail appropriate remedy permissible under the law. Apparently, breach may be there. Prima facie breach may be there.
Notice has gone to the
You seek damage.
termination or loss of
But
reputation.
it cannot be restored.
Item number 3.
Yes. Somebody made mention.
Yes, madam.
Yes, whether we have asked the state council to obtain instruction,
No, madam.
because here is a case. PDS license.
PDS license.
The license expired.
License expired.
The dispute is between
Stepmother.
son and stepmother. What kind of policy you have after date of the licensee?
They have to apply FS, my lord.
So this is phrase or what? Transfer of license?
No transfer, my lord. There is no provision for transfer, my lord. It is placed, my lord.
Okay. On the prayer of the council for the petitioner, leaves the case after we going to fix by the office. At morning it was mentioned.
Yes, madam.
So I thought that I asked the state council on the previous day, what kind of policy you have,
Yes, madam.
but you don't have any policy
My lord, they have to apply FS, my lord, because there is no policy for transfer.
because there is nothing in the APD order.
Yes, madam.
Item number 4.
Yes,
Well, on the last occasion, your lordship directed the respondents council to provide the letter, madam, issued by the Jilla Parishad. Letter number GLP, madam, 2480.
yes,
Malad instruction for it.
await it. Then we'll issue notice.
Delaying the case, madam, it's stay order.
Hard Mr. Ek Nikor Agor Fellow as Dr. P. N.K. Devnath. M. Chetia. As Dr. N.K. Devnath. Paragraph 2, paragraph 3. Paragraph 4 plus last time to Vadiba. Last time to Vadiba. Did you submit tender or not?
Submit.
Okay. On the previous date, comma, rate of listing, comma, 11/9/2023. Learned Standing Council, Panchayat and Rural Development Department sought time to obtain a to obtain and produce a copy of the letter bearing number Z full stop P full stop L 2480 stroke Polyhammery stroke 2023-2024 stroke 11 dated 21/8/2023 of the Lakhimpur Zilla Parishad letter. Today, Mr. Devnath submitted that he has not yet received the copy of the said letter and other necessary instructions. First, issue notice. Mr. Panigar, learned counsel for the petitioner, has submitted that the petitioner has submitted, without prejudice, his bid in response to the retender notice dated 31/8/2023. So issue notice returnable on 3 weeks, in 3 weeks. Having regard to the projections made, it is provided that till the next date of listing, the bidding process initiated by the retender notice dated 31/8/2023 shall not be finalized. Returnable date be delivered. Petitioner, any other extra copy? Okay, you accept notice for whom? One, and Mr. Devnath, you accept notice for 1, 3,
1,
3, 7. Okay, and M. Chetia, 2, 2, 5 and 6. The petitioner shall take steps of returnable on 4 weeks. 4 weeks. The petitioner shall take steps for service of notice upon the response number 4 and response number 6 by registered post within 2 of this.
1610. Item number 5.
A small accommodation. In this case, we have been led by Mr. K. Chodri. He is at present not there. On the
Come to 24.
last occasion, the instruction was sought for regarding the payment of.
No, this is an undertaking in a conciliation proceeding.
Yes, Lordship.
And your clear undertaking is that you will deposit the said amount on or before 31/12/2022. And this is a conciliation proceeding held for the payment of bonus under the Payment of Wages Act. And it is an industrial dispute where it is as good as a decree. It is only to be executed.
Lordship, what had happened subsequently, what had happened,
Subsequent, we are not concerned with. You have undertaken in a conciliation proceeding, and this conciliation proceeding has settled.
Lordship,
It is a settlement
Lordship,
and clear undertaking.
Lordship,
Now, what is in ID Act, what is the procedure for conciliation proceeding?
Lordship, what before.
We are not delaying something which is not
No,
just.
No, Lordship, just for a moment before going to the ID Act, Lordship, here in this conciliation proceeding, what was contemplated is that the amount of 14,17,623, page 24, that has to be given to the laborers.
No, let us, I think English is understandable. See,
Yes.
para 3.
Para 3, with
With regard to the area relief with wages
Yes.
from the tenure of Borhula Tea Industries amounting to
14,17,623
was raised by SEMS.
SEMS.
Accordingly, so and so shall
deposit
deposit the said amount. Said amount means
the 14 lakhs amount was.
on or before so and so.
Thus,
The said money shall be deposited. Now,
On-
how the money is to be deposited, that is also specifically provided.
account of AHC.
Now, just before that, the conciliation today settled at the following terms of settlement. So this is terms of settlement.
Councils, there are
Now,
four-
how ID Act, forget about 226, how ID Act has to go. Forget about 226. 226 is not always available. Where is the conciliation proceeding provided? Because payment of bonus act, any dispute regarding bonus is also an arbitrable, industrial dispute under the ID Act. So, where is the conciliation part? And this has become statutory. Conciliation, which part, Mr. Das?
Lordship,
procedure and power of conciliation officer. Yes. Item 11. Hybrid board.
My instruction is that the laborers have been paid and it's in the cash books.
Show me there.
Lordship,
Yeah, because bank deposit, show me bank deposit, that's all.
the laborers have been.
Then everything else is illegal. Every so-called notice issued thereafter is illegal. If you have deposited the same within time.
No,
See, this is a
concept.
this is, let us see what kind of color it takes.
Section 4, Lordship,
Section 4 of what?
of the Industrial Dispute Act. The conciliation proceedings start from.
Conciliation officers, board of conciliation, those are defined. Now procedure, power and duties of the authorities. Section 11.
Talks about the powers of the court, tribunals and national tribunals.
It is there, duty is 12. Subsection 3. If a settlement of the dispute or any of the matters in dispute is arrived at in the course of the conciliation proceeding, the conciliation officer shall send a report thereof to the appropriate government or an officer authorized in this behalf by the appropriate government together with a memorandum of the settlement signed by the parties to a dispute.
Then it is referred to
A
the.
settlement arrived at section 18. Settlement arrived at in the course of conciliation proceeding under this act, which has become enforceable, shall be binding on all parties to the industrial dispute. So whether this binding thing can be challenged in a writ petition. My question is this. Which has become binding, it has become section 18. Persons on whom settlement and awards are binding. A settlement arrived at in the course of conciliation proceedings under this act, which has become enforceable, shall be binding on all parties to the industrial dispute, meaning thereby it is binding on you. Now, binding award or settlement arrived at a conciliation proceeding under the ID Act can be challenged in a writ petition.
Lordship, here, we are not challenging the.
So what?
We are not challenging the.
He has got the authority now.
Lordship, in the given facts and circumstances, Lordship, what had happened is that the laborers had to get some dues, get the.
We are not concerned with that. We are concerned with your undertaking. You have given the undertaking in the conciliation proceeding that you will deposit that much amount and in a particular manner, in a bank account, right? That has become enforceable, no matter what subsequent issue. Now that has become binding on you. Now this binding thing, how can you challenge
No, Lordship.
in a writ petition? No, that is the only precise issue.
No, Lordship.
You are declining to deposit the amount,
No,
saying that this adjustment has to be made so and so, so and so, so and
No,
so.
Lordship, here.
So
what-
forth.
What was this?
And
conciliation-
why this so-called notices are bad?
No, Lordship, what had happened is that this conciliation proceeding was an outcome of a discussion. Now, in the conciliation, there were 4 things. Out of the 4, one was that we are.
That is what I have read.
There-
Mr. Das, don't say that.
Yes, Lordship.
Don't say that.
Four.
I have read already.
No, the.
I have read section already is read.
No, I'm not talking
If a
about
settlement of the dispute or of any of the matters in dispute
any of the.
or any of the.
Any of the.
So for 14 lakh is concerned, that has been settled
That has been there out of the 4, that is.
and that is binding.
Now regarding that amount has been paid as per the instruction.
Show me.
That's it is in the cash register. It has, and that has to be. I need just 1 week's time to just produce the thing. I'll be.
And if you further delay, I'll be imposing cost.
1 week time. Last.
I'll be imposing cost if you are not satisfying the
Lordship, what instruction is that?
settlement arrived at in the conciliation proceeding, no matter what, it will be less to it cost.
The instruction was that they have the money has been.
Show me
received by
then the bank statement. Show me. You have undertaken everything. There is nothing to deviate from. Page 24, nothing to deviate from.
Lordship, that-
It bears your signature.
No, Lordship, I'm not denying this thing. I'm
So
not denying.
how can you challenge this so cause notice?
I'm not denying. This thing.
No,
My.
I am
challenge
clear.
was-
Why you are challenging this so cause notice? He
Challenge
is
was
asking
that-
for what? He is asking for what?
Lordship, the money which has been, which the ALC is asking, that money they have already got, which they have paid to the.
Now, why you have approached without bringing any privacy material that you have satisfied?
Lordship, the cash register maybe, I may be allowed to.
Yes,
produce it.
Register, we are not going to do it. If it is money deposited in the account, Assistant Labor Commissioner, show me the document. That's all. We are not going to relax this kind of industrial dispute settlement. Writ petition, if you are aggrieved, writ petition is a remedy. After a binding award, an enforceable award, is it the writ petition is a remedy? Tell me,
Lordship, when.
show me from anything.
In a given facts and circumstances, when the, now, I'm asked, Lordship, what I feel, since the money is not, the money was, the proceeds was given to the ALC, ALC gave it to the laborer. Now,
Yes, sir, that is what, that money is given. So we have given time. You have prepared a writ petition with your own time. On the last date also,
Lordship,
I have given time.
Lordship, and so the.
So
instruction-
show me primary material that yes, I have deposited it. Enforceable binding on you. And clearly undertaken in the conciliation proceeding. Now, what kind of method you are adopting now?
Lordship, to that point, and at least till Monday or Tuesday, it will be released. Monday or Tuesday, I'll bring on the court.
If this is not, writ petition is not found to be maintainable, if this pedantry is not complied,
Monday.
and writ petition is not the remedy, you may go to other thing that yes, forcibly, coercively, whatever, go there to other forum. Try to recall the order, which bears your signature.
Monday.
On the request of Mr. R.J. Das, Learned Counsel for the petitioner, is the case on next Wednesday.
Deeply obliged.
The genesis of the writ petition is a settlement arrived at in a conciliation proceedings held on 29/2022, and the minutes of the conciliation is annexed at Annexure 4 to the writ petition. Who is there? On the other side,
I am for 124.
Mr. M. Setia, Learned Counsel for the Learned Junior Government Advocate Assam for the respondent number 124. And Mr. NC Das. NC Das, Learned Senior Counsel, assisted by Mr. A. Das. Learned Standing Counsel. Okay, learned counsel for respondent number 5 are present.
Item number 6.
Their notification, my lord, pursuant to, my lord, section 30, subsection 2. That, my lord, they are searching, my lord, they have not been able to find it. Because it may be of 1950 also, 60 also. So I will place it, my lord. Some time may be required.
Because this petitioners, even if in Nagaland or
My lord, they-
Manipur or anywhere,
they will have no right, man.
because of their ages,
Lordship,
they are not
my lord,
pre-independence born persons.
my lord.
So D might not be the ground
My lord.
for your original registration. Right. Should be either A, B, or C.
uh, 2 minutes, my lord.
So I also requested Mr. Sharma to find out anything
Lordship,
to satisfy at least ABC.
I have not on ABC, but
Hmm? Because you are insisting for interim prayer, so that other petitions interim prayer can subject to the other all the observations there.
because there is
All the observations there I have seen.
because there is alternative.
Will continue to the returnable date and it will be reviewed. So we'll annex list all the petitions
Yes, my lord.
and the interim order also be
Kindly,
revisited.
my lord, just kindly for 2 minutes, my lord.
Yes.
Page 353.
What is this 353?
352, because when,
What is this 353?
my lord, 352, just one page. Because at that time, they have done the verification from Calcutta, where some of the petitioners are registered under the Calcutta West Bengal pharmacy. Now this is issued by Register Assam Pharmacy Council to register as per resolution 5 passed in so on in the office chamber of the director. So you are directed to attend the office of the Register West Bengal Pharmacy Council, Calcutta, for verification of the genuineness of registration issued by the West Bengal Pharmacy Council to the candidates as per list and close and submit the reports to the undersigned for his presentation in the next meeting of the Assam Pharmacy Council. Now, pursuant to this, my lord, they next page 353. They went to the now Register Pharmacy Council Committee of my lord, directed by the General of Assam Pharmacy Council meeting held on to verify the register of West Bengal Pharmacy Council to see whether the applicant in Assam for reciprocal residence being registered by the West Bengal Council or not. We visited the Calcutta and West Bengal Pharmacy Council office at on at this. Now on verification we find that the name of the attached list were registered as pharmacies by the West Bengal Pharmacy Council. We also given to understand by the West Bengal Pharmacy Council that they have furnished no objection certificate for reciprocal registration of pharmacies in Assam were earlier registered by West Bengal Pharmacy Council. All the applicants of the list were found to be more than 18 years of age, except few all have renewed their registration duly. There we find no impediment for Assam Pharmacy Council to grant reciprocal registration to the person included in the list mentioned earlier. Accordingly, we are submitting the report for consideration and to allow the registration. Now,
Who is writing? Who is writing this?
they not
Self-certification.
they have
All right,
Pharmacy Council
this 352.
Yes.
Right.
is the register
To Abdul Mateen, to Ram Banerjee, to Prakhanda Sharma. Who are they?
member.
Okay.
Member of
Okay.
Assam Pharmacy Council.
What they do?
They went
We
to
find the name on the address list and register pharmacist. Right. We are given to understand by the so that they have furnished no of this reciprocal experience who were earlier so. So we are into the process of next registration. Now, Ram Prasad Bagaria. Ram Prasad Bagaria. Supreme Court. I've gone through it. So it has been clearly laid down that reciprocal state pharmacy council is well within its right to examine the credentials of the persons who has got pharmacist license from any other state and thereafter to decide either to register them or not to register them. It is clearly laid down. Now here is a question of public interest pitted against private interest. Now show me anything that you are satisfying. I have given you the example also. I do not want to repeat it. If Mr. Sharma has BA qualification, LLB qualification, you will have, even if suppose pharmacy council has seized your original, at least you have the particulars with you that I passed BA from this university and LLB from this university. Even if you forgot the year of passing.
I have only on 31D. I have that.
31D is, I have said to you, if you want to read again, we can read again. Because all these are 31D is applicable from the date of notification prior to, for persons who compounded for 2-3 years prior to the date of notification. And given by the ages of these petitioners, they are not in 90s, they are not 90 years old. Are they? Or 80? 70? I don't think so.
50. Now, there is also the alternative remedies available, but that part also been a lot people kindly see,
Because, Mr. Sharma,
my lord.
principles of natural justice is not a straitjacket formula.
Understood.
It can be post
My lord.
cancellation also.
My lord.
That is why I have been asking you,
My lord.
and I have been asking every petition. Show me any privacy material,
Yes, my lord.
similar order. Otherwise, I'll go by the observations made in the Bagaria case.
Yes, my lord. Because now 36(1), as per the 36(1), they have cancelled. My lord. Now they have required to communicate to me as per 36(4). Then I can go to the appellate forum. Now what they have done, they have issued the cancellation, notifying me only the cancellation date as well as the confirmation on the same date. Kindly Lordship will look into the act.
We'll examine that.
Yes, yes.
We'll issue notice at this stage. Because I was asking for some privacy material for passing interim order.
My lord.
Otherwise, we are issuing notice. We are not doubting about your case. Because since you are insisting that similar orders have been passed. Heard Mr. S. Sharma. Had it been a final order, I would not have deviated from that. How many? Mr. B. Gugoi, Standing Council, Health and Family Welfare Department.
All the response.
Which page cost title?
Madam, page 20, Lordship will find.
1, 2,
21.
All respondents.
all full stop. The petitioners, 22 in number, were earlier granted pharmacist license. Full stop. Show me any note whereby it is impugned.
Looking at page number, my lord, 330, 330.
330.
There are various implementations.
The petitioners are aggrieved by issuance of cancellation notice by the respondent, Assam Pharmacy Council, comma, annexed as annexer 106 to 100 annexer 127. 106 to annexer
351, my lord.
Huh?
Up to page 351.
350. Annexer 127.
127.
Annexer 127. Comma. Whereby the petitioners have been informed that their registration as pharmacists have been cancelled permanently under section 36(1) Roman small I of the Pharmacy Act 1948, and their names have been removed from the register of Pharmacy Council on the purported ground that the petitioners had failed to submit any relevant documents justifying their qualification to substantiate their eligibility to register as pharmacists in terms of section 31 within bracket small 1a or 31 within bracket small b or 31c or 31d of the Pharmacy Act, 1948. Full stop. The contention of the petitioner is that prior to issuance of those cancellation notices, proper opportunity of hearing were not afforded to them by the respondent authorities. And as such, the notices of cancellation are explicit in violation of the principles of natural justice. Issue notice, issue notice returnable on so and so 3 weeks. As Mr. Gogoi has appeared accepted, no formal notice, extra copies in requisite numbers within 3 working days. Please, the case. You tag Mr. Gogoi and you tag, give a list of all these pharmacy cases
Lordship.
and get the date of the notification,
That I will-
because every petition
Yes,
is relying on 31D.
31 due. Well, all right.
Item number 7.
Lordship, this regarding non-payment of contract.
Non-payment,
Yes, the lordship, on Monday, your lordship was pleased to pass orders, similar orders. sir.
not similar.
Yes. Same petitioner to define work orders, lordship, that's why lordship define this petition. Only item number 7 is similar to lordship WP.
7,
number
okay.
5435.
Mr.
Ace Mozumdar.
H. Moses, the petitioner,
Lordship, I
Pina,
have Lordship, I have furnished one copy of your order dated. I mean 3564 in the mail to check for mail to. You pass by, your lordship has passed this order, Lord. Similar set of cases, Lordship, by other contractor. Those were dismissed on the ground of delay. And it is a 2002 matter, Lord.
Lordship, on Monday, your lordship was pleased to issue notice and the.
on a preliminary point, I am
No, on one case, your lordship has issued notice because in those cases, one mandamus was already there. But in these cases, no.
Lordship was pleased to.
In case what?
Except in one case. No.
not, we are dealing with first case.
Yes, in the first case, it is there, Lord. In the first case, lordship, kindly.
H. Mozumdar.
Yes.
Petitioner, P. Nayak, Standing Council, PWD
Yes, sir.
for
For 1, 3, 4, and 5, Lord.
1, 3, 4, 5, Mr. B. Gogoi, Standing Council, Finance Department for the response number 2. Full stop. How many works, Mr. Council?
One work.
One work. Where are the
Item number
details?
7.
Details
Lordship, in the synopsis itself, lordship.
in the synopsis.
Completion certificate. Right.
The second round of litigation. Earlier.
Right, second round. Synopsis. Is synopsis of the work to, huh? Way to give it the injunction. It was exactly. Like a petition executed so and so and the first submission of so and so
completely similar.
WBC number
WPC number, your lordship.
2786, right?
Yes, Lord.
Disposed of 15/7.
15/7. Same date. please.
Shamsher Ali.
Amount is different, lordship.
Okay.
Amount 10,86,000.
Amount to change করে দিব একটু নায়ক করে দিব and ইয়াতে as নায়ক আৰু গগৈ লিখি দিব 4 weeks. This is item 7.
Second, your lordship. 8, lordship, item 8 to 13, your lordship.
8 to sound.
Your lordship was free to issue notice, and the issue of maintainability, your lordship was kept open for further consideration. Your lordship. And the lordship, similar order, your lordship, item number 54, WPC number 543 2023, your lordship. On Monday, your lordship was free to pass.
We have recorded Mr. Gogoi's submission while issuing notice
But I'm
that
just-
it is hopelessly barred by limitation.
Right.
So on the motion stage, we are not.
Only thing
This-
is one order has been passed by the honorable court.
Your
Single
lordship
bench.
has passed now.
It has been appealed by the division bench. That may be recorded in today's matter.
Okay.
Your lordship or not.
In the same.
And
matter, so no-
Mr. H. Mazumdar,
Yes, sir.
we are not dismissing it, Mr. We are keeping the issue of maintainability on the ground of limitation open to be
Yes, sir.
adjudicated on the returnable date.
Yes, lordship, because lordship.
H. Mazumdar and Learned Counsel for the, I have seen also your annexers.
Yes, yes.
I have seen.
It's okay, same work.
H. Mazumdar, Learned Counsel for the petitioner. Because another division bench order is staring at you. Mr. Nayak has produced it. And Mr.
Same lordship. I'm.
PWD যিখিনি আছে নায়ক কৰি দিব আৰু ফাইনেন্স আছে যোনটো গগৈ কৰি দিব। In this writ petition, the petitioner has sought for a direction to the respondent authorities to disburse an amount of rupees চাই ল'ব synopsisৰ পৰা against a contract work which was claimed to be executed by him on being awarded by the respondent PWD authorities. Claimed to be, yeah? Which is claimed. The contract work in respect of which the petitioner has claimed money is so and so. And the work order, pursuant to work order, work order what happened? Work order. Right, work order. So, 28 to 2002, page 2016. ঠিক আছে বাকি আগৰ order আছে Mr. Gogoi, Mr. Nayak, Learned Standing Counsel, PWD has submitted that the formal work order in respect of the contract work was issued as far back as on so and so. And as such, the claim of the petitioner is hopelessly barred by limitation. So stop. And Mr. Nayak has further produced a copy of an order dated 24/3/2023, passed in WBC number 3564/2022, wherein a reference was made to an order passed in writ appeal number 219/2022, by which the division bench had dismissed a similar claim on the ground of limitation, right?
Lordship.
Okay. Issue notice returnable in 4 weeks as so and so appeared accepted, release the case after 4 weeks. The question of maintainability of the petition on the ground of limitation is kept open for consideration for on a returnable date.
Lordship, that read appeal, lordship, that was, I appeared, lordship, in the single bench, lordship, if the read appeal was preferred, lordship, there are specific observation in the.
We'll see. I have not seen it.
Yeah.
I have only recorded Mr. Nayak's submission. We'll go into detail on the next day.
Delay is not the only matter, lordship. vigilance investigation is also going.
Okay, similar or amount will change kori dibo? Same petitioner,
Yes, sir, same petition.
same petitioner. Why you were sleeping for 20 years?
So it will be under petition
Up to 13.
up to 30.
Same
Same law.
amount to change.
Amount.
Koribo,
Lordship,
work order will change kori dibo.
Prepared amount and
Ah,
petition.
Okay, loi lo. Give the work order date also.
Work order date.
Item number 14.
Yes, after how many years?
2014, my lord, the work order is 2014.
Supply order.
Yes, ma'am.
Yes.
Thereafter,
Now we'll keep the other question of maintainability on ground of limitation. Open. Heard. Mr. D.K. join. Learned counsel for the petition, MS J. Gogoi.
Yes, sir.
Learned counsel representing RM Das.
Yes.
Learned standing counsel, Water Resources Department for order respondents, full stop. It is the case of the petition that on being awarded a supply order dated 16/4/2014, Annexure Roman 1. Comma, the petitioner supplied the articles in terms of the said supply order and submitted bills, final bill for an amount of rupees 2,07,529. When, despite repeated approaches made by the petitioner with the respondent authorities, the petitioner, it is stated, it is projected. The petitioner has approached this court seeking entirely a direction to the respondent authorities to disburse the said amount of rupees 2,07,529. Issue notice, MS, issue notice returnable in 4 weeks as MS so appeared accepted. No formal notice, extract copies to your list. Issue maintainable according to marketing.
14.
This is supply order or work order?
work order,
Huh?
work order.
Work order. Work order. Where is that?
Next is one, my lord, page number 10,
How many?
2 work orders,
2 work orders. Page.
page 10 and page 12.
Okay. After issuance of 2 work orders, Roman 1, work order number so within bracket an extra 1, and Roman 2, page 40 and extra page 10 or page 12 could be an extra like a part of it. Final bill amount for against the said 2 contract works 4,20,274. Payout asset. Issue notice return to MS Gogoi. All the respondents?
No, one is government.
Huh?
One is government.
MS J Gogoi. Again, RM das times the likhib. 1, 2, 3.
2, 3, 4, 5.
Huh?
2, 3, 4, 5.
Then in the other case also?
Yes.
No, secretary, if you are standing counsel,
One
okay,
is government.
one only, I am Setia. Why you are making one a party? Unnecessarily. One. I go to 1. Child over chief secretary. 2, 3, 4, 5. J go good. Limitation.
Item number 16.
And item number 21.
Same.
21 and 26, my lord.
You wait for some time. We are going serially.
Happy New Year. Hello, in this case, my lord, you challenge the impugn order at page number 60, my lord.
60.
60, my lord. Where our
Yes, 60 fishery.
First of all, my lord, come to the page number 57, my lord.
50?
57 with evaluation meeting, my lord.
57.
CL number,
Yes,
CL number 1, this is my name, my lord. Petitioner name Pradeep Das.
Pradeep Das.
Yes, named the Secretary of the Educated Unemployed SC Youth Health. নামৰ গোটেই নিবিদাৰ লগত মাছৰ অভিজ্ঞতা প্ৰমাণপত্ৰ ভাৰতীয় পোষ্টেল অৰ্ডাৰ প্ৰথম বৰ্ষৰ 15% আমানত ধন 40,100 টকা বেংক ডাক আকাৰে জমা দিছে। নিবিদাকাৰী ফটো কোডটি গোটৰ বছৰেকীয়া লাভ লোকচানৰ হিচাপৰ কপি নিৰ্ধাৰিত সময়ৰ ভিতৰত ৰাজহ আদায় দিবলৈ সন্মতি শপতনামা আয়কৰ মুক্ত প্ৰমাণপত্ৰ বাকিদায় পত্ৰ অনুসূচিত জাতি প্ৰমাণপত্ৰ দাখিল কৰিছে। নিবিদাৰ লগত গাঁঠি দিয়া তথ্য সকলো নথিপত্ৰ শুদ্ধ পোৱা গ'ল। This is my lord in respected date. Now, my lord, respondent number 6, my lord, that page number 58, my lord.
50?
58, next page.
58.
My lord. He is also, his name also.
His name? Punaram.
No, my lord, Pradeep Das, my lord. He is also Pradeep Das.
Pradeep Das.
Yes, ma'am.
Both are Pradeep Das.
Yes, my lord. Society is defined, my lord.
Respondent number?
6, my lord.
Okay.
5, sorry, my lord.
5.
বৰপাক মীন শিল্প সমবায়
Lord.
সমিতি লিমিটেড সম্পাদক হয়।
Hmm.
নিবিদাৰ লগত মাছ মৰাৰ অভিজ্ঞতা প্ৰমাণপত্ৰ ভাৰতীয় পোষ্টেল অৰ্ডাৰ নিবিদা ফটো কোডটি নিৰ্ধাৰিত সময়ৰ ভিতৰত ৰাজহ আদায় দিবলৈ সন্মতি প্ৰকাশনামা আয়কৰ মুক্ত প্ৰমাণপত্ৰ বাকিদায় প্ৰমাণপত্ৰ অনুসূচিত জাতি প্ৰমাণপত্ৰ দাখিল কৰিছে। প্ৰথম বৰ্ষৰ 15% আমানত ধনৰ 40,000 টকা বেংক ডাক আকাৰে 95 টকা কম কৰি জমা দিছে। ডেফিচিট। অন্যহাতে উপৰোক্ত মীন শিল্প সমবায় সমিতি লিমিটেডৰ নামত 2019 পৰা 2025 বাবে তেখেতৰ নামত লিজত আছে। গত বৰ্ষত তেখেতে প্ৰথম বৰ্ষৰ 8,100 টকা আমানত ধন আৰু 10,000 টকা সৰ্বমুঠ 6,000 টকা কোষাগাৰত জমা দিছে। বাকী কেইবছৰৰ 2020 পৰা কোনো ৰাজহ জমা দিয়ে। Now, my lord, this has been forwarded
So
to the-
Pradeep Das, Pita Kamal Das.
Yes, my lord.
His bid is correct.
Yes, my lord.
Okay.
I'm the second highest bidder, my lord.
Okay. Then what happened?
My lord, respondent of 5 is the.
Let us see page 60. This is
My lord. This is forwarded to the government, my lord. My lord, government evaluated this, my lord.
page 60. Where is your
This is my lord. First.
evaluation?
Yes, my lord. Educated unemployed.
This is 60%?
Yes, my lord. 60%. 60%. Now, my lord.
This is seal number 1 is petitioner.
Yes, my lord. Petitioner society. Educated unemployed SCA.
You are not society as it appears. Self-help group.
Self-help group. Self-help.
Second has bid.
My lord. From the
Pakijai.
From the scrutiny of document, it appears that following the, my lord, there is a 7 ground.
7 ground.
Yes, my lord. Pakija certificate in the individual name. Yes, my lord, in my individual name, my lord, not my
How many members you have?
11. my lord.
11.
My lord, my Pakija certificate is page number 66, my lord, in the name of the secretary.
Now, how self-help group is to be formed? Any legal status
My lord, page number, my lord.
for a self-help group? What is the provision?
My lord, page number 22, my lord. In the town committee, my lord.
What is the requirement? Page 20?
22, my lord.
So town committee gives the register, what?
Yes, my lord.
Huh?
Yes, my lord. As per register number of state self.
Okay.
PTC 58.
So what kind of formalities a self-help group is required to maintain? It is
11, my lord.
it is some kind of legal entity or association of persons only.
My lord, association of person, 11 person.
Only association of persons. And generally gets registration from town committee, etc.
Yes.
But what is the requirement? Not in the name of SAG, Bakijai clearance certificate. What does the tender notice says?
In the tender notice,
Take me to the clauses.
I'm not finding any stipulation. There is no stipulation.
No Bakijai.
No, my lord. Tender notice at page number 30, my lord.
No Bakijai. Required. What?
Bakijai required, my lord, at page number 31.
31.
Yes, my lord.
Hmm.
প্ৰত্যেকখন নিবিদাৰ লগত আয়কৰ বৃত্তি পৰিশোধ প্ৰমাণ কৰাৰ প্ৰমাণপত্ৰ
Clause.
ক্লজ মাইলত 11 খ
11.
প্ৰত্যেকখন নিবিদাৰ লগত
Bakijai.
প্ৰমাণপত্ৰ নকল থাকিব লাগিব দিছ stipulate the মাইলত self-help group. My Bakijai certificate is in the name of my lord.
Now, whether individual person, their liability will be different.
Hello.
Their liability as a person is different. But as a collective body, the self-help group, as a collective body, their liability may be different. So that group is not required to obtain Bakijai clearance certificate.
In the name of my lord, secretary, my lord.
Secretary, where?
Page number 66, my lord.
Yes,
Yes, Bakijai clearance certificate, my lord, from the Bukakhat subdivision office.
No, this is individual, Did not. right?
He's the secretary, my lord.
Huh?
Odipras is the secretary, my lord.
Secretary, but it is not given as a secretary of self-help group. I am not sure about the legal status of a self-help group. That is why I am asking you. Mr. Gugoi, you may have your own individual thing.
Yes.
And you suppose you have formed a self-help group. Their liability will be different. You will have 5-10 more persons there. They may incur a liability collectively. So that liability might have belonged to that self-help group. So what?
In the tender, my lord, there is no stipulation, my lord.
But that is why I am asking you, what is the self-help group?
My lord.
So many infirmities they have recorded. Will issue notice at this stage?
My lord.
Yes.
We are going to
caveat, my lord, for the restaurant number 5, and we have also taken position. That may kindly be the
Heard, Mr.
Lordship, restaurant, but we are wrongly made it.
My lord, wrongly made it, my lord.
Our name will be strike up.
Wrongly made it.
Mr. D. Gugoi,
My lord.
learned counsel for the petition. Mr. M. Setia, learned junior government advocate Assam for the response number 1, 2, and 4. MSMD Bora, learned standing counsel transport department for response number 5. And Mr. M.K. 3, and Mr. M.K. Churi, learned senior counsel assisted by Mr. DJ Methi, learned counsel for the caveator stroke response number 5. The petitioner, comma, the petitioner hearing representing a self-help group in the name of educated unemployed SC youth SG has preferred the instant petition to challenge an order of settlement dated 28/8/2023, whereby, a fishery named Honhiri River Fishery, district Golaghat, a 60% category fishery, has been awarded has been settled in favor of the caveator stroke respond number 5 for a period of 7 years at its offered bid value of rupees 21 lakh for 7 years at rupees 3 lakh per annum, treating the bid of the respond number caveator stroke respond number 5 as the highest value bid. The petitioner has assailed the grounds of rejection of its bid in the instant petition. Mr. Chaudhary, senior counsel appearing for the caveator stroke respondent number 5 has submitted that pursuant to the order of settlement dated so and so, the respondent number 5 society has already taken possession of the fishery. Issue notice returnable.
Submit a copy of it.
Ms. M.S. Bora, Standing Counsel, Transport Department has submitted that the respondent number, both Mr. Gugui, Learned Counsel for the petition, and M.S. Bora, Learned Standing Counsel, Transport Department, have submitted that the respondent number 5 is not a necessary party for adjudication of the issues raised in the involved in the writ petition, and therefore, the name of the respondent number 3 be deleted. Be deleted from the array of respondents. Full stop. In view of the above submission made by so the name of respondent number 3 is deleted from the area of respondents office to carry out the necessary correction in the writ petition and rearrange the respondents accordingly. Full stop. As এইটো 1 2 3 এইটো অলপ কাৰেকশ্যন কৰি ঠিকঠাক কৰি প্ৰথমতে কৰি দিব এইটো প্ৰথমতে কৰি দিব M. Chetia, Mr. Chetia, prepared, accepted 1 2 4. Mr. Medhi 1 2 and 3. Previously 1 2 and 3 previously respond number 4. And
I'm
Five. 4.
Medhi. For the respond number 4. Previously respond number 5. No formal notice, extra copy you need to open it. A copy of the possession certificate. Mr. Chaudhary has placed a copy of the photocopy of the possession certificate dated 19/9/2023, whereby the possession of the fishery has been handed over to the respondent number 5 or respondent number 4 society. Previously respondent number. Our last one kept as part of the record. 17. Yes.
Well, here the petitioner is challenging the bids accepted by the respondent number 2 of private respondent number 3 and 4. Well, the e-tender was issued on 12/5/2023 by the respondent number 2, that is the Assam State Textbook Production and Publication Corporation Limited. Your Lordship will find it page 20.
20.
And the bid standard conditions are page 22.
Page 22. Yes.
Bid conditions, the Lordship find 1.9 I'm relying. 1.9.
Hmm.
Bidder must have a minimum annual turnover of rupees 1 crore or above for each year of the last 3 financial years, 2020-21, 21 to 22, 22 to 23.
So then this respondent did not submit for 22-23.
Yes, the
Okay.
respondent number 4 did not submit it, fulfill this condition. And 1.10,
For 22-23,
yes, ma'am,
others they have submitted.
others. And as
What
far
was the
as
last date?
last date, the financial bid is already open, and
No, what is the last date of tender submission date?
tender does the last date of submission was 1st of June 2023.
1st of June.
It's written in tender schedule, clause 4,
Page 22, date of submission of tender is 1/6/2023.
and last date of submission of tender 1/6.
2023.
And my lord, and as far as clause 1.10, the bidder should have be up-to-date income tax returns for the financial years 2019, 20, 2021, and 2022. So the respondent number 3,
1.9 you want to say about R4.
R4,
Okay.
and for respondent number 3 has not complied with this 1.10. And as per general condition 2.2, both the private respondent has not complied with this condition.
Certificate from
Mint.
reputed.
Reputed.
Now, how do you define reputed?
My lord is reading
How do you define reputed? That is one difficulty.
waste paper recycling industry or
Some may be reputed, some may be disreputed.
but they
In the
have
eye of one may be reputed. In the eye of the second person, he may be disreputed.
not submitted any certificate
Any
from,
certificate.
any certificate
Okay.
from the mint
Okay,
industry.
waste paper recycling industry, irrespective of reputed.
Irrespective of reputed or
Okay, waste paper recycling industry.
where the papers are recycling. And
And what is the stage?
now
Because 1.9, that is the ground you have raised against respondent number 4, non-submission of annual turnover.
yes,
That
it's
could
the
be a
status of-
region which is relatable to the last date of submission of bid.
Yes,
Right.
correct.
That may not be, he is not in a position, if depending upon his turnover and income, he may not be in a position legally to submit this
1/6,
details.
1/6, not probability.
No, if his accounts is to be audited, then the last date is 30 September.
30th September.
Then he may not be. So we cannot preempt everything. So for respondent number 4 is concerned,
As far as clause,
what is the stage now?
the
Bid opening done.
bid opening done, but the financial evaluation and AOC has not been done. I have checked it. It's
Online.
Online.
Hmm.
It's
Anybody represents
my lord,
contesting respondents textbook?
Mr. P.N. Goswami is the standing counsel. We have served a copy.
You have served a copy. Anybody assisting Mr. P.N. Goswami? We can find out. Can you inform somebody assisting P.N. Goswami? Because ultimately it is a tender process. If they you can stall it for a moment, but
We have
if your contentions are not found standing on proper ground, then it will be stalling a tender process. So where is Mr. Pingu Sam? Please inform somebody. Please
And in the
try to get anybody associated with Mr. Goswami. We'll take up after some time.
18, item number 18.
But the petitioner before you launches is operating a private go-hart miner.
Private Gohat.
That is Katmamari private go-hart miner. And the
Cattle market.
cattle market. And when a petitioner approached before your lordship miner for illegal action of the respondent number 7 miner, the officer of Fokirganj
Respondent number 7.
that is Fokirganj police station miner. And
Officer 6.
that's not 7 man.
No, you're done it wrongly. Somebody has corrected it without signature. Now all these things are required to be corrected properly. See, where is in your cost title, where is respondent number 4?
The super respondent of deputy commissioner. Yes. Chronological method mistake.
Your things are corrected.
No one.
No, I don't know who has corrected here. Without any signature.
Then Friday method.
Better.
Kindly allow me to
এইটা
correct.
signature তোমার correction করা হয়েছে, signature করা। তেওঁলোকৰ petition Better you file an amended cost title, this 2 page. I think there is a process now. Mr. Council, you file this 2 page as per notification. Then office will carry out the correction.
If lordship permit otherwise.
No, nowadays this is not done. Mr. Aki Sharma, Learned Counsel for the petitioner, has submitted that as there is some mistakes in the area of respondents, comma, an amended, he wants to file an amended cost title in terms of the notification dated so and so before the arresting full stop. The prayer is allowed, leaves the case on next Wednesday. Prayer is allowed. To file it by today.
Item number 19.
May I please, Lordship?
Yes.
Market BTC. Lordship, NIT was issued on 27/6/2023. Page number
NIT, page
21, Lordship.
Page 21, which market?
Lordship,
Edit video.
Balipara weekly market.
এখন ঘৰৰ ফাইলটো থৈ দিব এই ধৰ টাইমিংটো বালিপাৰা উইকলি
Weekly
মাৰ্কেট
market. And type copy is page number 19, serial number 1. And the petitioner was participant. And as per the comparative statement, petitioner was the highest valid bidder.
highest valid bidder
As per the comparative statement. And type copy is page number 22, serial number 2.
highest bidder
Highest bidder, yes, Lordship. 1
you
lakh,
cannot say as of now highest valid bidder
Lordship, his bid value is 1 lakh.
oh that one GST yes
Yes.
okay
After 2017 GST is mandatory. After 2017 GST mandatory.
GST is not submitted
Not submitted.
then is it a requirement
Lordship,
of the NIT
NIT it is stated if necessary,
If
but after
necessary.
2017 it is mandatory.
Lordship, but kindly see the page number 7, my petition.
yes
Lordship, as per the CGST Act 2017, if anyone has an aggregate turnover in a financial year which exceeds rupees 20 lakhs and taxable supply of goods or services or both, then he shall be liable to be registered under this act and state or union credit. Lordship,
paragraph 7
Lordship, paragraph, page number 7, paragraph 7, Lordship. such a large portion.
But did you examine the tender form?
Lordship, tender value is 42,320.
Did you examine the tender form? Here it is made optional. Did you examine the tender form?
Yes, Lordship, if necessary.
In the tender form. This is tender notice.
No, Lordship.
Because I have examined. There, that optional thing is not there, perhaps.
Yes.
Okay, this is for market.
Balipara Utti market.
Yes, he has raised an issue.
Lordship.
GST is not applicable. So that has become optional, and that is also indicated in the tender notice. That is what. Okay, heard. Mr.
S. J. Sohoria.
S.
J. Sohoria.
J. Sohoria, learned counsel for the petitioner, and Miss R.B. Bora, standing counsel PTC for the respondent number 1, 2, and 3. By tender notice dated 27/6/2023, the respondent number 3 invited bids for settlement of a number of market, including a market named Balipara Weekly Market within bracket Wednesday.
Saturday, Lordship.
Again, wrong timing.
Wednesday.
Again, wrong typing. Is it not?
Yes, Lordship.
So earlier repetition was directed to be withdrawn because of wrong typing, and wrong typing on a material thing. Now again, same kind of mistake. That is why I have stopped relying on translation thing. Because you have made me to not to rely on translated things. Even you are not aware. Assamese version is Wednesday, and you are yourself is saying Saturday. First, in response to the tender notice, the petitioner, four number of bidders submitted their bids, including the petitioner and the respondent number 4. First, as per the comparative statement prepared by the respondent number 3, the petitioner had submitted all the requisite documents to certificates, except GST certificate. Full stop. The bid value offered by the petitioner was highest, bid value of rupees 1,01,000 offered by the petitioner was the highest, whereas the respondent number 4 had offered a bid value of rupees 65,200. Full stop. But the respondent PTC authorities has settled the market by an order of settlement dated 2/8/2023 in favor of the respondent number 4 with effect from
Go ahead, collection.
1/7/2023 till issue of a formal settlement order within bracket Annex 3. It is the contention of the petitioner that the tender notice itself had indicated that submission of GST certificate was an optional one. Full stop. It is further contended that if, as per the CGST Act, 2007, if anyone has an aggregate turnover in a financial year which exceeds rupees 20 lakh in terms of taxable supply of goods or services or both of them, para 7, such person shall be liable to be registered under the CGST Act in the state or by under the CGST. As the petitioner's annual aggregate turnover in a financial year in terms of taxable supply of goods or services or both did not exceed 2020 lakh, he is not required to be registered under the CGST Act, and as such, the GST certificate was not submitted along with the bid issue notice returnable 4 weeks, 3 weeks, as MS 4 weeks, as MS when to appear accepted. Petitioner shall take steps for service of notice among the respondent number 4 by registered post date.
My lord, we have challenged the settlement order dated 18/7/2023. My lord, issued
Where is
by
that?
the respondent number 3 in favor of private respondent number 6.
Where is the settlement order?
My lord, Annexure C,
Page
page number 26.
26. Yes.
My lord, bid value of the private respondent number 6 is prima facie defective. My lord,
What is your bid value?
my lord, my bid value is 7,51,000.
Below him.
Yes, my lord.
Okay.
Well, the respondent number, private respondent number 6 submit the land valuation lower than the bid value.
How? How?
How, my lord, kindly see.
Certified that the land, valuation of land covered by the number so from Amargaon, Kishan, Singhiya, Putani, Moja,
Well,
recording
kindly
name.
see page number.
Who is respondent number 4? Name is Pahanta Bora. Vishnuram Bora is fixed at rupees month per bigha. Proposed land value. 2 katha plans has been fixed at 6%. Diagram was been fixed at 6%. And so what is the total figure as per page 23? What is the total? Total of it?
My lord,
There are 3 figures.
Yes,
So what is
my
the total? Have you calculated?
yes, my lord.
What is total?
My lord, total is 5,51,846.
5 lakh
51,846.13.
846.13.
13.
13 paisa.
Yes, my lord. Kindly see page 7, my lord. In my petition.
Okay. What is the requirement?
My lord, the respondent number 6 did not submit the consent letter.
What is the requirement in the tender notice?
2 lakhs, 2,19,000.
Hmm?
Government value is 2,90,760.
Which one? Government value?
At page 13, madam, is the translated copy.
Page 13.
Yes, madam. Otherwise it's there at page number 16, madam.
Government value 22,91,000.
19.
Now, what is the condition?
My lord, private respondent number 6 did not submit the consent letter of
Now,
co-Bhattacharya.
what is the condition? What is the condition in the tender notice? You don't know. Yes, Mr. Devnath, come to page 18, clause 14. নিবিদাকাৰী অথবা জামিনদাৰে নিবিদা মূল্যৰ ওপৰত not the government value মাটি জামিন হিচাপে দিব লাগিব. So his bid value is 7,80,000. And according to land valuation, if it is correct, then page 23. And as per statement made in paragraph 4, consolidated amount is 5,51,846. So it is below.
Whether this, the petitioner is stating this, whether by virtue of clause 10, the respondent who has been actually offered the bid has subsequently
Don't speak about clause 10.
3 days time that is given in case some documents are not.
I don't say about clause 10. Don't argue about clause 10 here. Whether valid bidder or not valid bidder.
As of now, from the records that have been produced, documents produced by the petitioner, it's not clear. It shows that it is less. But whether this is all actually, that's actually a different story.
Get the records then. Hard MS
M. Alam.
M.
Alam.
Alom. Learned counsel for the petitioner, Mr. N.K. Devnath, learned standing counsel, Panchayat and Rural Development Department for the respondent number 1, 2, 3, 4, 5. 1 to 5. Full stop. By a tender notice dated 6/5/2023, comma. Borhampur Anchalik Panchayat invited bids for a number of markets, including a market named Borhampur Weekly Market, by fixing its government value at rupees 22,19,762. Full stop. In response to the tender notice, a number of bidders, including the petitioner and the respondent number 6, submitted their bids. First of the respondent number 6 had offered a bid value of rupees 7,80,000, whereas the petitioner offered a bid value of rupees 5. How much?
5,51,846.
7,51,251. By an order of settlement, dated 18/7/2023, the respondent Panchayat authorities has settled the market in favor of the respondent number 6. Full stop. It is the contention of the petitioner that clause 14 of the tender notice required that either the bidder or his guarantor had to submit lands stroke land documents as guarantee, which must have a valuation above the offered bid value. Full stop. By referring to a land valuation certificate dated 23/6/2023. Land valuation certificates. Two land valuation certificates, both dated 23/6/2023 within bracket annexer B series. It is contended that the total valuation of the land offered by the respondent number 6 was only 5,51,846.13, which was below his offered bid value of rupees 7,80,000. Such yet the respondent authorities have settled the market in favor of the respondent number 6, who is to be declared as an ineligible bidder. Issue notice returnable on after returnable on the date of 4 weeks of return, as Mr. Devnath has appeared and accepted notice 1 to 5, no formal notice, extra copies, 3 working days. The petitioner shall take steps for service of notice. Response of 6, that goes to BD, 3 working days. In view of the projections made that the respondent number 6 is an ineligible bidder, the land standing house is required to file its counter affidavit on behalf of the respondent panchayat authorities on or before the returnable date, or otherwise, shall produce the relevant reports of settlement.
Item number 21.
How old?
2000,
How old?
2015.
15. One work order.
2 work orders.
Okay. 10 or
10 or 12. 10 and 12.
our amount is 9,99,636. J. Gugoi to B. Z. Bokolial 1. J. Gugoi RM Das 225.
26, 3 work orders.
26 page.
10, 12 and 14.
Z. Bokolial. File over. Chief Secretary Jyoti. Now, Mr. Jain, you are filing so many petitions. Don't make this respondent number 1 as party.
Okay.
This is unnecessary impediment. Secretary of the department is the highest authority in the department. See, amount to silo.
23.
Please, Lordship. Lordship, this is regarding a tender wherein I was awarded the tender of 10 number of buses in the TPS.
Hmm?
I was awarded the tender.
You are awarded.
I was awarded the this tender
What, who is the tender?
in page. The award is in page 41.
Tender notice?
Tender notice, page 18, Lord.
Huh?
Page 18.
This is tender, best tender number.
This is
Page
the tender
41 is the tender, work order,
letter of award.
letter of award.
I was awarded the tender
Okay.
for mobilizing 10 buses in DPS.
Ah.
Accordingly, I have purchased the 10 buses and I have handed over 10. I went to hand over the 10 buses on 9th of this month. Thereafter, they have informed me that they cannot take my buses as one of the bidders have filed a commercial suit in Dibrugarh.
The tendering authority, page 41.
DPS. I was awarded this tender.
I'm asking about tendering authority.
Delhi Public School.
Is it a state?
No.
Is it an instrumentality of the state?
No, actually,
Is it an entity amenable to the jurisdiction under Article 12 of the Constitution of India? Is it a public sector enterprise?
no, they are run by oil.
Is it a government company?
No.
Run by Oil India does not make it an instrumentality of the state. So, whether they are discharging public function? Apparently, no. So, had they been discharging, admitting students, saying that only persons having income above 1 crore, their students will be admitted, other students will not be admitted. That could be a discharge of public function. Now tell me, by what manner it has a public element? It is not a state. State government does not have any control. It is not an instrumentality of the state because state does not have any pervasive control. It does not finance this authority. Now, Oil India may be an instrumentality of the state just because it finances or it runs under the aegis of. It is not run under the aegis, under the aegis of Delhi Public School
Delhi Public
Society.
Delhi
That
Public-
itself is a private body.
Yes.
So the question of maintainability comes to the fore. Yes, Mr. Kolda, you represent whom?
Lordship,
You are on caveat or what?
no, Lordship, on the basis of the instruction I have appearing Lordship for Delhi Public School. Lordship, what happened is in this case, Lordship, by challenging the lower court order, Lordship, a FAO was filed in this this honorable court, Lordship. By
Challenging?
challenging the order passed by the learned lower court, Lordship, by rejecting their prayer for injunction, Lordship. They have filed a FAO, Lordship, by one Borua Industries, Lordship, in this report, FAO number 25 of the 2023. In this case, Lordship, a interim order was passed, Lordship. Interim order was passed.
Now, what is the case? NIT was issued by Delhi Public School for procurement of bus.
Yes,
Huh?
yes, sir. And accordingly, they were participating. in
LOA was issued
the- Yes, sir.
in his favor.
But there is this interim order passed by this honorable court, Lordship.
Interim order?
Yes,
No,
sir.
that is FAO, that is in civil line,
Yes, Lord.
that is suit
Yes, sir.
and thereafter appeal.
Yes, Lord.
Now, we are in REIT.
This rate is not maintainable, Lordship. I'll.
We are in REIT, Mr. Counsel. There is a suit. Who filed that suit?
Lordship,
One
on
of the
Borua
contesting
Industries,
bidders.
they were informed, Lordship, last annexure that has been challenged, Lordship, 13/9/2023, Lordship, whereby the Delhi Public School has informed the petitioner about the status of that case, Lordship. against that order, Delhi Public School has already filed a stay vacating
Mr.
application.
Counsel, you take your proper counseling. Then you file this writ petition.
I think last. date was
Monday,
the 30th.
Tuesday, Wednesday, question of mentality you address. We have not found anything. Go through all the articles in the constitution, as well as all the authorities. I am giving you time. On the prayer of Mr. S. Nag. S. Nag, Learned Counsel for the petitioner, has sought listing of the case next Wednesday in order to address on the mentality of the writ petition under Article 226 of the Constitution of India. Mr. K. Kolita. Learned Counsel has entered appearance on caveat for the respondent number.
I am appearing on the basis of instruction, Lordship. Telephone
Okay.
instruction.
On the basis of, has Mr. appeared on the basis of instruction on behalf of the respondent
Respondent 1 and 2.
1 and 2. List the case.
Obliged.
Item number 24.
Yes, hired Mr. A. Rahman,
My lord,
Learned Counsel for the petitioners.
it's 17 in order.
Mr. M.S. N. Bodu. Revenue 1, G. Bokolial 1, 2, 3, 4. Yes.
Page
What is
17
your case?
Page 17 is the impung order, my lord.
17.
My lord. The petitioners are
In pursuance of additional deputy commissioners for instance, the following is the writers have cancelled as per swing of the registration. Yes, what is 14.7?
14.7 registration
Okay,
manual.
I'm good. What is 14.7?
Not find out, my lord.
Registration manual.
My lord.
Oh, you have straight away filed a writ petition without going through what is 47.
License are cancelled without assigning any reason, your lord.
So just because license is cancelled. Yes, MS Bodily registration manual.
I don't have it right now with me.
No idea.
Oh.
Nobody has any idea. Mr. Bokoliar has any idea.
My lord, there is no section like 14.7. It should be 14.1, I think, my lord. And the post in question is not governed by 14.1, my lord.
Wrong coding of provision does not make any difference if there is power on the part of the district registrar to cancel the
My lord.
license. But question here is, it appears from the order that primacy there is violation of nature justice. Right. Heard Mr. A. Rahman, Learned Counsel for the petitioners and Bodule, SPNU 1, petitioners, huh? G. Bokolial. Junior Government Advocate 234. The petitioner has assailed. Petitioners have assailed an order dated 38/2023, Annex 3, passed by the respondent number 3, whereby the petitioners did write the licenses have been cancelled, partly in exercise of the powers conferred on the respondent number 3 under the provisions of the registration manual Assam. Issue notice returnable in 4 weeks as necessary. Please address on the next day,
Yes.
My lord,
except extra copies.
maybe
Item number
state, my lord.
25.
Impung order may kindly be state, my
Oh,
lord.
no,
They have become jobless.
We don't know what is your record. You have not annexed only one document you have annexed.
My
That order is a appropriate order you have annexed.
Obliged.
If we find there is violation of natural justice, definitely it will be revived.
Right.
But you have not read also under what provision your license has been cancelled. You are not bothered, right? What is registration manual? What is deed writer? Have you seen the registration manual? No.
Have that online method.
Online not available, so not required. Throw to the court, writ petition. Court will decide. Court will find out the registration manual, decide the writ petition. I will simply file the writ petition.
But while cancelling the license, there could be reason.
That's all. Yes, next.
Number 20.
Made to the lordship. I am in petition in person today, my lord.
Okay, petition in person.
Yes, my lord.
Okay.
Here, my lord, the subject matter is, my lord, that petitioner company earlier applied for, my lord, building permission for construction of apartment. Then, my lord, the NOC was also issued, and my lord, certain, my lord, regarding zoning, my lord, certificate was also issued. But, my lord, since at that time, my lord, some personal mishap happened, my lord, because of the.
At this stage, we can issue notice here.
I think, my lord, he can take instruction. Let me place the case, my lord, page 15, your lordship.
Which?
15, 1-5. The letter is issued by Chief Executive Officer 2007-2011. With reference to the subject cited above, I am directed to inform you that the site referred above falls in residential zone as per master plan and zoning regulation for Guwahati approved by the government of Assam. I that not so read it Assam so and Korean so. So, my lord, accordingly they proceed. Then, my lord, the Commissioner GMC has written another letter, page 18, my lord. That page 17, to the Chief Executive Officer, Guwahati Metropolitan, that last paragraph, your lordship, see, paragraph 4, in view of above, you are requested to re-examine the same as per the master plan and zoning regulation and clarify the plot of land as this described in schedule below. Falls in eco-sensitive zone or the residential zone. Then my reply has come next page, page 19. The CEO has written again to the Commissioner GMC that after verification of new master plan, it is found that zone already mentioned in this office letter dated so and so is correct. Page 19. Thereafter, my lord, accordingly they have proceeded, my lord, GMC authority has proceeded, and my lord, the NOC was also page 23 and exercise 6. The NOC was typed and it was ready for issuance. But my lord, then my lord, the husband and father of the director, my lord, died.
How could you access this document? It is not signed.
And it was in the file, my lord, they have given us GMC authority. It was not my custody. It was, everything was ready. But because of some mishap in the company, my lord,
How a public order is to be issued? This is 23 is not a public order.
No, my lord, I am
Anyway,
questioning
this
about
is not neither signed
zone.
nor dated, right?
Because they make it ready, because otherwise my lord, it was ready. Then my lord.
No, we
issued a
cannot
letter.
take cognizance of page 23 because of the law.
Yes, my lord.
Then
But
what happened?
yes, my lord. Then my lord, now my lord, when applied, it is my lord, page 24, certain amount was deposited, 3,57,000, this, my lord.
For permission.
For fresh permission, because
Okay.
a letter at that time, my lord, a letter was issued, but it took my lord 4 years.
So,
But
sum and substance that you require permission.
require permission. Everything is fine. GMC authority, GMD authority, everybody has.
Yes,
visited that site.
Mr.
But my lord, I have written a letter on 21 July 2003 On that letter, they have inspected everything, my lord, but regarding the zone, some confusion is there. But my lord, in the adjacent plot, from the, because the original owner was same, adjacent plot, they have given my lord permission and they have erected two tower, your lordship might have seen Thanapara. So my lord, it is the common boundary wall, because the original son, same that number, same patta number. So you.
So you have already submitted an application along with the fees
Yes, my
for
lord.
permission.
Lordship, one
Yes,
is building permission and the second one is NOC. Building permission is granted by the GMDA, NOC by the GMC. Status of this case is at page 21, Lord.
Hmm.
With reference to the above, your proposal for construction building boundary wall at Swadesh Nagar, Khanapara could not be processed, therefore refused for the following reasons. So this is the last status. Lordship.
No, last status means that letter was 17, but it was my lord, received my lord, I have stated in the my lord, when the director visit my lord, they have handed the offer in 21. So we came to in 21.
Anyway, the responses are required from the GMD and GMC.
Sure, man. And thereafter.
We can
we
issue
have-
notice at this stage.
They have directed to issue my lord, apply for fresh permission because the area is also now very different. So accordingly, I have deposited the press fees on.
Okay, let them
24,
respond.
23. Yes, my lord.
Let them
They have
respond.
taken Instruction. So that my lord, your lordship. can
Yes, Mr.
issue my lord.
Lordship, Lordship.
Will issue notice.
Otherwise also.
All are represented.
Yes, Lord. I'm with you.
So that
You
it
can
should be
represent both, I think.
disposed
Yes,
of
Lord.
in
GMD,
And GMC.
GMC.
Let
Since
it
he is
be
represent,
Instruction and my lord is sorted, my lord. It can
no,
be
let them,
disposed of by the-
will issue notice,
Yes.
like, returnable maybe, since he is representing both.
Yes, my
We need not have to send any notice, further formal notice. So, for what date?
my lord, motion stated.
Within 3 weeks. 3 weeks, we'll fix a date.
Lordship. Otherwise also to my information, Lordship, my learned colleague is in consultation with the GMD authority, Lord. They are having some negotiation also.
Anyway, we don't know.
Yes, Lord. But
If you
this is-
decide among yourselves,
Yes.
it
So
is
we can
okay.
arrange
We have
that would
nothing
have
to
been
do.
Decided,
Whether-
they have
But if
informed me
you-
that that
if
would
the-
have been decided there.
If the things are to be adjudicated, then we have to see. Heard MS N. Hoikia, petition in person, and Mr. P. Nayak, Lion Standing Council, ZMDA, Roman and GMC for all the respondents. Full stop. Okay. The petitioner is a private limited company, represented by the petitioner in person as the honorary director. Most of the case of the petitioner is that it sought no objection certificate and building permissions for construction of a multi-storied
Building.
apartment buildings. Apartment buildings. Full stop. The process of obtaining such NOC and building permissions started in the year 2011. Full stop. After receipt of objections from the respondent authorities, the petitioner company has submitted a fresh application seeking such NOC and building permissions on 28/4/2023 by depositing the requisite fee. Full stop. para, according to the petitioner, comma, the respondent authorities have also carried out the necessary inspections on the plots of lands. Full stop. Yet, comma, the NOC and the building permissions have not been issued till date. Aggrieved thereby, comma, the petitioner has approached this court by this writ petition. Full stop. Issue notice returnable on before puja vacation date 13/10. As Mr. Nayak appeared accepted, no formal notice, extra copies in requisite numbers, but by tomorrow? By tomorrow.
12, 12, 12, the Friday night. Can it be 12?
No.
Monday, Friday,
13 is,
Friday. Can it be on?
you want an
Thursday?
auspicious day, 13, okay. Then 11. May not be an auspicious day, 13
What that he has given,
or 15.
any date, my lord.
11. 13 is not an auspicious day.
Very bad, my lord.
Okay,
My husband also died on 13.
okay, 11 then.
What will happen? But
11,
suddenly
11.
he died without any detail.
Lots.
11,
Can
11.
we make it 12 lots?
How long?
Not 12, then, we'll not,
11,
I mean, then 16. 16. 16.
16 is my lord.
Monday.
Monday.
Auspicious?
Of life. No, my lord, 13 I really afraid of. Many things have happened. My brother also died of.
Accepted, accepted.
Of like that.
Item number 7. 27.
MS.
Please, your lordship, this matter relates to non-payment of.
Yes, your name, please.
S. Chakravarti.
S. Chakraborty. Learned counsel for the petitioner. B. Chaudhary.
Yes.
Learned standing counsel, agriculture department for all the respondents. Full stop. The petitioner was awarded a supply order dated 20/12/2019, comma, paragraph 3 बोल के दिया. According to the petitioner, comma, the petitioner carried out successfully executed the supply order and submitted a final bill amount for a sum of rupees 2,90,000
9,000.
99,000
99,000.
99,880.
Eight.
So as the respondent authorities have not yet disbursed the said amount, the petitioner has approached this court seeking inter alia direction to the respondent authorities for disbursement of the said amount of rupees so and so. Issue notice returnable in 4 weeks as Mr. Chaudhary appeared accepted. Extra copies 2 days.
28.
Yes, yes, will issue notice
Matter may be taken up at
2.
like
Yes, Mr. Google.
Otherwise, my lord, same pharmacy. is fine.
Same. Okay.
leftover item number 17.
Sorry, Your Lordship, you overlooked it.
Yes.
Lordship, here the challenging the tender process, Your Lordship, but they're saying that the private respondents, they lack documents while submitting it. But as far I know, as per his writ petition, no one has been allowed to tender, Your Lordship, till now. Staying this process even blocks him from getting the tender if he's selected, Lordship. This is selection the primary basis, Your Lordship.
Hmm?
This is a selection. No one has been allowed to tender till yet, Your Lordship.
Right. He's saying that the respondent number 3 and respondent number 4,
Exactly.
their bids were not compliant to the tender
Yes, sir.
tender conditions. One is that 1.9 clause, page 22. 1.10. 1.9 is in respect of respondent number 4.
He's making,
And 1.10 is in respect of respondent number 3.
yes, Your Lordship,
And clause 2.2 is in respect of both.
both.
And that is their case.
He's merely making statement. He has not annexed any documents showing that they have not annexed these documents or whether they have complied with it or not. They're merely making statement, Your Lordship. And right,
Anything indicating that they have not, because it is e-tender.
E-tender, I had actually, I appended, annexed it at the very beginning, I annexed those documents. But since these are downloaded from the net, most of the documents are not very legible. So the registry took an objection. And I have leave of this code to produce at the time of hearing.
Okay.
I have prepared a paper book that these documents are there.
Okay. Anything in the document annexed to the writ petition?
no document, Your Lordship.
Well, if page 70 is the tender summary report.
Page?
70 is the tender summary report.
Their bits are here.
Yes,
Let us see which page.
my lord, page 185.
185.
I have fact mark. This is regarding respondent number 3. This is the
Pertaining to clause 1.10.
1.1.
1.10.
Yes,
Yes, what does?
this is for the assessment year 1920, which will be the financial year 2018-19.
Assessment year.
Assessment year 1920.
It means that financial year is 2018-19.
18-19.
Okay.
So there is a clear violation. They have complied with this.
So if financial year is 2021-22.
Yes.
That means assessment year would be 2022-2023.
Yes.
Now, then also the same question. Sometimes if accounts are required to be audited, then 30th September.
I have submitted, madam. I have submitted.
You have submitted, but last date was available to them under the statute.
But that.
So if they did not submit,
That,
whether it is an offense, no?
but the violation of the precondition of the bid.
Because that is required. And this tender clause maybe that something which is to be tested against the provisions of the Income Tax Act. Yes, so far, what is clause 2.2?
Yes.
These are
Regarding I'm keeping.
something which is to be tested against the provisions of the Income Tax Act.
Yes.
Let this matter be taken up Friday. I'll produce the original records from the department, Lordship. We'll go to record that.
Good enough.
Till then, no, should not be finalized.
Don't take any action.
Well, Lordship.
They have to taken till last night.
Right. Okay, fine. It will be listed somehow. I'm not, I will not be sitting. Mr. Edhorn and Council Board Application is present on the prayer of Mr. R. Google and standing council.
Assam State Textbook Publication.
Textbook publication. So and so lays the case on sorry, Friday. In the motion column.
Obliged, Lord.
Well, can it be on Monday, 25th? Very well.
Monday, I do not know Monday.
Because,
I can fix it on Friday.
I had some update.
Monday, everything is doubtful.
Supplementary list for motion
Publish.
item number 51.
The contracting counsel for the application has legs in code 20 matter. I am kindly pass out the matter for time.
We'll see after the motion.
52,
Matter may be taken up.
Hmm?
Matter may be taken up too.
Otherwise, my lord, matter has become infructuous.
Yes, why?
Because my lord, only grievance of the petitioner is that my lord, the technical bid and financial bid has not been opened and uploaded. As per my instruction, on 8/8, my lord, technical bid was uploaded.
8/8.
And petitioner was found to be, my lord, technically viable. So his apprehension has gone. And my lord, in the financial bid, he is L2. So otherwise, my lord, so far as the prayer made in the writ petition, those are made.
Oh, financial bid is open.
He is L2. I got that. Also.
That's the.
Okay, let Mr. Kotogi come.
53,
My lord, the petitioner is agree for the settlement of Marga in favor of the.
So, Mr. Khan,
My lord,
that day it came, right? That day it came. Where is standing council? Panchayat.
the last day also.
On last day also. Okay, you got the settlement at 7,700.
My lord, that was lost.
Correct or not?
Right.
Yes or no? Yes.
I have been entrusted to.
No, come to page 12.
This to-
Is it you?
My lord, that was the earlier settlement.
Previously, see,
My lord,
7,700.
for certain period, not for 1 year.
Whatever.
Well.
Up to June 2023.
From February.
Up to June 2023.
My lord,
Oh, you are beneficiary of same nature. In pursuance of the decision of the meeting dated 9/2/2023 of the General Standing Committee, Pekamari. Oh, without tender.
that was without. Tender.
Oh,
Now,
right.
I am agreed, lordship, by the.
Now, when tender notice published,
My lord, that tender was. for-
I'm asking a question.
My lord. There are,
When tender notice was published,
my lord,
why did you not participate? You did not participate?
my lord, nobody has a offer tender.
Are you offering now same amount? Are you offering the same amount?
No, lordship.
No.
Nobody has a offer any tender.
Nobody offered,
My lord,
right?
including the petitioner.
Right.
My lord.
Now come to page 43. Are you offering the same amount?
No, lordship.
No.
No.
Then
My lord, my grievances is that this.
when tender notice published,
My lord,
you did not participate.
my lord,
You enjoyed the Pargat, right? Without tender, right? Thereafter, tender notice published.
Well.
Nobody turned up.
nobody. has-
Now, what the Panchayat authorities do?
My lord, that is.
Now they have found somebody who offered an amount, right? Figure is there, page 43.
My lord.
Now tell me, are you offering this amount?
But,
You enjoyed it at 7,700.
my lord,
Tender notice published. Nobody participated.
nobody, but
Now, the Panchayat authority had found a person who had offered 1,01,000.
that was not in tender process.
You did not participate, Mr. Khan.
My lord,
Is it clear or not?
yes, absolutely.
Now, on the second question, are you offering the same amount or higher? Tell me.
Petitioner may offer. lordship.
Tell me. Are you ready to offer the same amount or higher amount? You did not participate. Clear as water. Then Panchayat authority, having seen that this is not settled
And there is public purpose also behind it. People, ferries, right? This is what, Parghat? Somebody offered 1 lakh rupees. They accepted it. You are not offering 1 lakh.
My lord, I have.
Are you ready?
My lord.
Are you ready?
That aspect, lord, I have to obtain instruction. And so.
Heard Mr. M. Khan, learned counsel for the petitioner. MS, who is? Naam to likhibo.
My lord, page 41, I have been entrusted to collect the tolls. When nobody was,
M. Khan, petitioner. Pending counsel likhibo. Naam matini 1 to 5. The petitioner was earlier settled with Ghugura Kandi, Parghat, without any tender process. For the period from 13 to 2023 to 36 2023 by an order dated 10 to 2023. Full stop. The settlement amount was fixed at rupees 7,712. Full stop. A tender notice was published by the respondent Fekamari Anchalik Panchayat on 4/5/2023, inviting bids for a number of markets, Parghats, etc., including Ghuguramari Parghat, by fixing the government value at rupees 22,112. Full stop. The petitioner did not submit any bid in response to the tender notice dated 4/5/2023. Full stop. The petitioner has stated in this petition that no bidder submitted any bid in response to the tender notice dated so and so in respect of Ghuguramari Parghat. As a result, Ghuguramari Parghat went unsettled in the tender process. Full stop. The petitioner is now challenging an order dated 8/8/2023 within bracket Annex 6, whereby pursuant to a resolution taken by the General Standing Committee of South Salmara Mankasar Jila Parishad, the Ghuguramari, the Parghat, named Ghuguramari Parghat, has been settled with the respondent number 6 at a price of at a settlement amount of rupees 1,01,000, and subsequent to deposit of the said amount by the respondent number 6. Full stop. Issue notice returnable in 6 weeks, as Mr. Devnath. 1 to 5. Petitioner shall take state for service of notice upon the respondent number 6 by registered post will be ready within 2 working days.
Section list item number 1 promotion.
Why wrong listed eviction? Why making wrong mention wrong code? Mr. Council, eviction is not bench sport. Settlement rules 18(1), 18(2), 18(3),
Yes,
Assam land and regulation rules.
bench 5 matter.
Why they have made them mention? Saying different thing, market. They were running a market over government land. Now they have been served with notice under 18(1) of the settlement rules.
Yes.
So it is essentially a eviction case,
Yes.
not market case.
Yes.
They were running market over government land unauthorizedly. I don't know why they have misused the permission. Next.
For admission, item number 29.
Non-payment.
My lord, affidavit has been filed, my lord.
Dispose of
They
lordship, verified pay, your lordship.
Well,
Am
day before yesterday, your lordship passed an order, my lord. Here is same matter.
What is an WBC number?
Document number 358. I prefer.
Same order will do.
Okay, heard Mr. P. Talukdar, learned counsel for the petitioner. And Mr. R.R. Gogoi, learned standing counsel, Public Health Engineering Department,
All the responding, your lordship.
for all the respondents. Where are the work orders? How many?
3.
3. Page
From each 12, your lordship.
page আপনার 14, page 14, 17,
20.
and 20.
Well.
Begin cyber লিখে দিব। What is the amount?
Amount, my lord. 500,061.
5,61,000. Affidavit paragraph 3. Affidavit filed.
File, your lordship.
Admitted.
It's 5,61,000.
Okay.
My lord.
Your synopsis says
I have challenged the tender notice, Lordship may kindly see my prayer, Lordship. Lordship may kindly see my prayer. Page 13, Lordship. Lordship, we are evicted, we cooperated with the eviction, Lordship. We are doing business in that particular plot of land, Lordship.
no, that is private government land.
That is government land, that is just introduction, Lordship. Lordship, my prayer is may kindly be seen at page 13. A writ in the nature of tertiary should not be issued by setting aside the impugned tender notice dated 2/9/2023. A writ in the nature of mandamus or any other appropriate writ or restraining the respondent from finalizing the tender process, because there are 2 arbitrary clauses which makes us ineligible to lordship to make our bid, lordship. Lordship, in the tender notice, your lordship will find, lordship.
But your synopsis says different thing.
So, lordship, second page is also there.
What does your synopsis says?
Lordship, initially, Lordship, when the eviction was executed, Lordship, we are given assurance that we will be given first preference when the shops are allotted. They did not do that. They had issued the impugned tender notice, and there are 2 arbitrary clauses in the impugned tender notice. That is clause P3, wherein, Lordship, the requirement is that we have to give 3 years income tax clearance certificate, and clause P8.
Which is what tender notice?
Tender notice, Lordship, we have page. Annexure 4, page 21. So, and today is the last day, 20th September, of submitting the tender bid. And Lordship, I am agreed by Lordship clause 3(3), Lordship.
No, what kind of tender notice it is? For what purpose?
For allotment of Lordship, if your Lordship comes to page
Temporary
27.
list
If,
and
Lordship may kindly
augmentation
come to page 27,
of revenue.
room, Lordship. Under Kharovanda, Daily Bazar.
Page 21.
Page 27, Lordship, that particular map is also there. Allotment of this room of 9 into 15 pages.
Page?
Page 27. Lordship, we will participate in the tender process, but Lordship, this arbitrary clause.
What arbitrary clause? Which one?
Clause 3.3, Lordship, the copy of income tax clearance certificate at least for previous 3 years, and 3.8, GST clearance certificate of at least for previous 3 years. Lordship, we are small petty businessmen like Lordship, vegetable vendors. We are small tea stalls. unstopped, Lordship.
They have a right to set a pre-qualification criteria.
Is there, Lordship, but small space, Lordship. we are
That
also working-
everybody cannot participate everywhere.
But
Then if this is permitted, you can submit bid for railway projects also, huge railway projects. So some pre-qualification criteria is to be set.
only some small space.
Set.
We are doing business for last 7 years there. And we
No,
fully cooperated with the eviction also.
this is what, on what basis you are running?
Plus, we have also paid some toll. If there was
Huh?
English, we annexure 1, pay 16.
On what basis you are running?
No, now lots of we have.
By tender process?
We have vacated lots. We have vacated.
No, what right you are claiming?
Only because.
You are who? Who are the petitioners?
Petitioners lots is the, there were some small petty businessmen. Lots of.
Right.
Yes.
So what talent, petty businessmen?
Petty business, they were doing lots of, they are vegetable vendors, tea stall owners.
You were allowed to set up shops there,
Yeah.
right?
And district administration executed the eviction losses. We fully cooperated. But we are given assurance that we will be given first preference and whether allotments are given. Now. losses-
Where is that
that,
undertaking?
no, that is only verbal. loss. No undertaking. So we fully.
And they have invited tenders for giving it the entire thing on lease,
Please.
right? And you will be running your business under that lessee,
Under,
right?
under the Jilla Parishad.
That lessee will be given that particular plot, right? Lease amount will be collected. And thereafter that lessee will collect tolls from the businessman. And you are those businessmen. Is it not? Then
Government has-
how your credential and vis-a-vis the tender clauses can be termed to be arbitrary?
Small.
Yes, so far,
Yes.
after that lessee, yes, you can demand about something which is shops. But you cannot challenge the tender clauses, Mr. Das.
How this small petty business will have.
No, where from you are getting this page 27?
Page 27 is a part of the lordship annexure 5 document notice. In continuation. of the
Notice
tender
income,
procedure.
huh? Which annexure 5?
Annexure 5 page 20.
Let us see. In continuation, tender notice, tender, tender.
This is a part of the notice. This is a diagram. Lord.
Hmm?
This is they have set it as enclosed diagram.
Mr. Das, I'm not understanding page 21. Page 21 is for lease of 1 bigha land.
Sure.
Is it not?
Sure.
So one has to bid for the entire 1 bigha.
Lordship, that has already been settled with the Jilla Parishad. The government has already settled. Government has already settled that particular plot of land with the Jilla Parishad.
No,
And the
land
Jilla
has been given to Jilla Parishad.
Yes.
Now, Jilla Parishad is inviting tender
Yes.
for lease
For
of that plot of land,
plot of land.
right?
Sure.
And for that, the bidder has to satisfy conditions in page 23,
Yes, sir.
right?
Yes.
Then, are you bidding for the entire 1 bigha land?
No, only for particular stock lordship. That number is there. There will be 34 stocks. Page 27.
That is subplotting
Subplotting.
under that 1 bigha.
Yes, only for this particular subplotting lot, 34. One.
Huh.
That is of 9 into 15 feet.
Right?
Each row.
Who will do it? Who? Because
page 26.
tender notice.
Selection committee will finalize temporary allotment process by observing all formalities. Who will allot those shops?
Chief executive officer. Chief executive officer of the Jilla Parishad. They have floated the tender.
Yes, Mr. Panchayat. Have you served copy to Panchayat or not?
We have. Lordship, the GST registration certificate is required, Lordship, when there is a business of more than 20 lakhs. We are small business, Lordship. How do you get this GST registration? And that too, Lordship, we have stopped for 3 years previous clearance certificate. Lordship, we may
No,
allow-
I am not understanding the scheme of the thing. Firstly, the entire plot of land is to be settled with one particular bidder. And within that plot, there are shops,
Shop.
right?
Shop.
About 34
Shop.
shops. And those are going to be allotted.
Okay.
In what manner, they have not mentioned. You are basically interested in those subplots,
Subplot.
not the plots.
Lordship, this is for this,
Are you submitting tender against the tender notice?
against the subplot, Lordship, that page 27 for particular stop. For the particular stop.
For that, you can challenge that thing, that page 26, that allotment should be made with a criteria. But for that, you cannot challenge this tender notice. You are not bidding for it. You are interested in your respective plot within that market. Right, subplots.
Subplot, but this is also a part of the tender law. Tender.
You can say that this should not be done.
Terms and conditions, Lordship, may kindly see page 23.
We can only see that this subplotting, allotment of subplots should not be made till the returnable date. But you are not the bidder for the tender notice.
No.
Why should we stall? You are not bidding for that. You are not responding to the tender notice.
We are not bidding for the entire 1 giga plot of land. Only for
Right.
the shop, yes.
So you cannot
We cannot.
stall that.
And Lordship, the tender notice is only with regard to, but that has not been explained, Lordship, in the tender notice.
Okay, we can only stall subplotting, allotment of subplots, but we should not stall the tender process. Returnable date.
Yes, my lord.
Panchayat, Panchayat.
My lord, go to the page, my lord, 17, my lord. Actually, my lord, they are unauthorizedly occupying their plot of land, my lord. That is why, my lord, after it was settled with the Panchayat.
Now they are saying they have vacated that.
Yeah, okay.
Now thereafter, that land has been allotted to Panchayat.
Yes.
Now Panchayat has issued a tender notice and for settlement of that land. And thereafter they intend to run some shops there by collecting perhaps tolls from that shopkeepers. So they are agreed by that,
Not by the eviction.
not eviction. Hard,
And
Mr.
Lordship, the,
I have not read your petition.
and Lordship, the notice dated 8/9/2000 is a continuation of the tender notice. Page 26.
I have seen it. This is what, this one is subsidiary.
Yes, Lordship, in continuation of the tender notice.
I have seen it. Where is Panchayat?
Can be after some time, my lord.
Call them, otherwise. Next one.
Leftover item number 28.
Yes,
May it please your lordship, this relates to the cancellation of the licenses of the pharmacy. Your lordship, we have been registered in another state. That is our initial registration. Subsequently, in terms of section 32B of the Pharmacies Act, we have been registered. Now, there are several round of litigations. Now, there are certain guidelines that have been framed by this honorable court saying that a show cause notice followed by personal hearing should be provided to us.
Followed any privacy material,
Your lordship, that show.
any privacy material that you qualify either under 36(1), 36(2), 36(3).
Your lordship, what I want to say is that they have not issued me the show cause notice. Your lordship will.
So that is why
Yes,
you are all in all the writ petitions. Only condition is that proper opportunity, principle of natural justice violated. Now, you need issuance of notice or issuance of or any interim period.
your lordship, honestly speaking, the order was passed on 12/6/2023. Today, it's 19/7/2023. 1 month is elapsed. The only thing is that if they can take instruction that whether the requirement of the statute as well as those judgment has been followed in my case, then I have nothing to say. But if that has not been followed, your lordship, in spite of that, after that order, there was a list, a notification, wherein they have published the name of all those pharmacists whose license has been cancelled. My name does not appear there, except petitioner number 4. So they say that cancelled.
Show me any privacy document.
Your lordship,
You have qualification of B Farm, or you have matriculation with so and so, or C. Come to
31D.
come to come to 132. Do you have any degree or diploma in pharmacy?
Your lordship, I have been registered.
Do
under
you have?
No,
Then do you hold any degree from Indian
no,
University
your lordship.
and plus engaged in compounding? No.
That
Then have you passed any examination?
no,
Recognized as adequate?
no.
Hard, Mr.
31D, your lordship. I fall in 31D, your lordship. Until 2013, they have
31D. That is, see, Mr. Gogoi, I have been asking you repeatedly.
That my lord will, I'll produce.
your lordship will kindly see the
What is the meaning of 31?
31D. The meaning of 31D is suppose I was,
Pharmacy Act.
I'll just explain it, your
It
lordship.
has to be read with section 30.
Your lordship, 31D is the, it says that.
Let us read.
Yes.
Let us read slowly together. Let
Yes,
us
sir.
understand.
Yes, your lordship.
Has been engaged.
Has been has been engaged in the compounding of drugs in a hospital or dispensary or other places in which drugs are regularly dispensed on prescriptions of medical practitioners for a total
For a total period of not less than 5 years. Prior to
the
date
notified
to
under
be
section.
notified under subsection 2 of section 30.
Yes, your lordship.
Right.
Yes,
We are into Pharmacy Act 1948,
right. Your lordship.
right? Section 30.
30 is preparation of the first register.
Hmm.
Now, section 30, subclause 2. The state government shall by some same or like notification appoint a date on or which before an application for registration, which shall be accompanied by prescribed fee, shall be made to the registration tribunal.
Now,
I'll-
what is the date?
I'll pause there for a moment, your lordship. I have made a categorical statement that these pharmacists were initially, the first registration was done at in respect of,
Nagaland, Manipur, Bihar, Uttar
Bengal.
Pradesh, Rajasthan,
Fine.
Tamil Nadu, Maharashtra.
yes, your lordship.
Yes.
Now, a registration tribunal has to be constituted in that state. And if prior to that date, I was practicing as 5 years as a compounding in the compounding or dispensing of drugs, I apply for the license. And I have been issued. with
Show
the-
me that of a original state.
I have made a statement, your lordship. And on the basis of that, I was registered under section.
Now
32.
come to page 33, paragraph 18 and 19.
Selected.
Yes, your lordship.
So State Council has the power,
Yes, your lordship.
scrutinize.
Yes, your lordship.
Now what tangible document you have
Your lordship.
annexed in support of your claim that you are a pharmacist,
Your lordship,
fulfilling any of the conditions?
it is an admitted fact, although I have not annexed the matric, HSLC pass certificate.
Yes, I have passed orders in at least how many? 20?
Yeah.
Your Lordship,
Nobody,
that day also
nobody
I-
has annexed any document. Hired Mr. R. Sinha. Learned Council for the petition. We are public interest versus private interest.
But your Lordship, the only
And
issue is that-
Bagaria judgment has said,
the only issue is that, your Lordship, they should come up in a manner. 36(1)(1) says, your Lordship,
principle
categorically,
of nature justice is not a straight jacket
I
formula.
admit, your Lordship. But the
So
statute has to
even
be read in a
post-
manner,
Post order,
your Lordship. the
decision,
statute
post
has to be
decisional
read in a
hearing can
manner.
we also afford it. We can afford you post decisional hearing. Provided. And that will be set aside.
Your Lordship.
Show me any tangible thing.
Your Lordship, when the impute
16
action on their
number.
part is a straightway, it's snatching away my civil rights, your Lordship. And the section 36(1) category.
Civil right is pitted against public interest.
They have not stated as if that be the case, why I was registered till 2009.
Have you gone to Bagaria judgment?
Yes, sir.
What does it say? Only 1819 quoted. If you go through that entire judgment, what does it say? So that unqualified pharmacists should not be permitted to continue because there will be great hazard to the public health if they run pharmacy
I admit.
and
your Lordship.
dispense and drugs, medicines to gullible patients.
But the fact is that whether they
Ah.
followed the procedure while they have dismissed
We'll
me.
examine, mister. We are not closing your case. We are not.
Your Lordship will see. In fact, before intimating me, they have already taken a decision to remove me. your Lordship.
pass করছে না? What is
Item
that?
number 6, your Lordship.
Same.
Yeah, item 6.
Your cancellation,
My cancellation is at page, your Lordship, it starts at page 186.
186. Up to annexer
17, 191, your Lordship.
17 to annexer. Only one.
No, your Lordship, 6,
It starts from my lord 186 to my lord
191.
191.
Okay. Annexer
12 to annexer 17.
12. Annexer 12. to annexer. Annexer 12. R. Sinha.
12 to
Big
17.
boy.
your Lordship.
Papa date inside you. Agor order same.
On the respondent.
But Mr. Google, please find out the date.
That my lord I will try.
Leftover item number 51.
Deeply obliged.
Again, petition is not there.
Hmm.
He was there. You were not there earlier. Next.
Deeply obliged.
Okay. Yes, how to come out of the situation?
My lords, if my lords grants me time till Monday, I'll come back with the instructions. If something has to be done, if the rules have been violated, my lords, we'll have to probably correct them. And as far as his
Fine, lord.
allegation goes,
Let him, your line is existing, your building is existing.
yes, lord.
Now remedial measures, right? Okay, R. Sharma for the petitioner. Bagi naam kita likhi do, ya B Chaudhary likhi do, ha? KB bata bata. Mr. Chaudhary, standing also. A petition has short time till next Friday,
Wednesday. or
next
Friday.
Wednesday to obtain instructions in Yaman.
Deeply-
Place the case accordingly on such.
Item number 52.
No.
We're supposed to bring instruction regarding the NIP.
Instructions that instruction is to the effect that technical bids were open, financial bids were open.
We're open, man. But whether we are qualified or that,
Technical bid qualified, price bid L2.
So my lord, the prayer lordship may see at page 17, 15. Already my lord made it up.
So
14.
by the corrigendum,
yes,
you were not ousted,
I'm not out.
but it has been diluted
Diluted.
to have more participation.
First one, because a new,
We don't know about blue-eyed boy. Mr. Gugoi can only tell,
yes.
but otherwise it is
corrigendum whereby some clauses have been amended.
Amended, earlier.
And you say that that will make more inclusion of somebody
No
eligible.
No point.
But in the meantime,
Corrigendum was issued in July. He would have challenged it immediately. He waited, my lord, for a long time, my lord.
That I understand, madam, because they was not uploaded by, they were not aware of it, madam. That's the difficulty.
But that result, I
if you want to challenge, you challenge it.
Yeah, let me ask my client. Confirm.
Okay, we can keep it pending.
Yes, madam. Let's.
Okay. And
But pendency again, my lord, it will not. be a
no, we
bar
are
to
not
go ahead.
issuing notice.
No.
Let him take instruction what to do.
Yes, madam.
And you provide that on the next date,
Lord.
because at least some breathing space is to be given to him also.
Lord,
He has come to know in the court only.
Yes, madam.
My statement will be recorded that it is inspector.
Okay, then give that document, copy of the
It's there,
document. Mr. P. Kotoki, learned counsel for the petitioner, heard, and Mr. B. Gugoi, learned standing counsel, Health and Family Welfare Department for respond number 1 and 3, and Mr. G. Bokolia, learned MS.
Prepare for respondent 2 and 4.
Yes, you represent Central Government Council.
Yeah, go.
K. Gugoi, Lihibo, MS.
NN Sharma.
NN Sharma, learned counsel, representing Mr. K. Gugoi, learned Central Government Council for the respond number 2 and 4, full stop. Mr. Gugoi has submitted, Mr. Gugoi, learned standing counsel, has submitted that after expiry of the bid submission date, the technical bids of the participant bidders were evaluated,
Right.
wherein the petitioner as well as other bidders were found technically responsive.
No, my lord. 5 bids were received, 2 were found to be responsible, including the petition.
Another bidder, another bidder, another bidder. And to stop thereafter, the financial bids of the two technically responsive bidders were evaluated
On 10/8. 10/8.
on 10/8/2023. And after technical evaluation, the petitioner was found to be L2 bidder. Mr. Kotoki, counsel for the petition, has submitted that the case be listed on next Wednesday in order to enable him to obtain further instructions in the matter. List the case accordingly. Answer it. Have you got a copy?
On the rates, I cannot argue, madam. Only on the whether there he is, whether that he will.
Now only financial bids evaluation.
For admission item number 31.
So 1 week time may be allowed to file my affidavit, my lord.
Mr. A. Chakravarti, learned counsel for the petition is present. MM Kotoki, learned standing counsel, Animal Husbandry and Veterinary Department for all the respondents, appearing for all the respondents, has paid for and is granted 2 weeks time to file affidavit in opposition.
Obliged.
Please the case up, please.
32.
Yes, Mr.
My lord, writ petitioner challenged the approval of the cattle market, my lord, under BTGA.
That
And
was
BTGA
cancelled perhaps long back.
My lord.
Affidavit, my lord.
Affidavit, I don't know.
It is already filed. Only cancel.
Cancel.
Cancel, my lord. The market was cancelled, which was,
Subject matter has become infractious.
that is the main.
Mr. Rosid has already withdrawn his petition.
I have not known, my lord.
That is another
No, no,
matter.
no, my lord.
No, what?
No,
What is
nothing
left?
left, my lord.
Huh?
Nothing left, my
Nothing
lord.
left.
Nothing left, my lord. Only
Mr. K.D. Shetty, learned counsel for the petitioner, Mr. P. R.K. Musahari, learned standing counsel, BTC. Any standing counsel, PNRD, no. BTC.
BTC only.
N.K. Devnath, standing counsel, Panchayat and Rural Development Department for respond number 1, R.K. Musahari, learned standing counsel, BTC for the respond number 2, 3, 4, 5. Mr. G.K. Bokolial, and 8 also. And Mr. G.K. Bokolial, learned counsel for the respondent number 6 and 7, and Mr. A. Rashid. A. Rashid, you appear for?
Respondent.
No, you are not there. I have submitted that the subject matter of the writ petition has become infractious in view of the withdrawal
No, no, my lord. In view of the Alexa rate 20 pace, my lord, which is.
In view of cancellation. Cancellation of the letter dated 12/10/22.
22.
Full stop. The repetition is accordingly disposed of as
With all
infractuous.
respect,
Infractuous.
infractuous, my lord, if that word is used, displease and infractuous were repetition
Disposed of.
or disposal, with all respect, my lord.
Item number 33.
Highly applied.
Yes.
The matter relates to non-payment of contractual works of the work admitted for the year 2017, Lordship. An amount of 15,22,000, Lordship.
No instruction. Get your instruction, Mr. Bokulial. Who is the respondents? State of Assam DGP.
Lordship.
Take your instruction. P. Bordoy, learned counsel for the petition is present. Mr. G. Bokulial, learned junior government advocate appearing for all the respondents has paid for and is granted 2 weeks time to obtain instruction as regard admissibility or otherwise of the claim made by the petition in this writ petition. Please the case after 2 weeks.
Lordship.
34.
Can I tell you?
Contract use.
Outline.
Maybe. This is where regarding payment of money in Europe.
Sometime. Photocopy. Photocopy. Get the
Yes, sir.
records itself.
Service completed as per my official note,
It has come in admission column.
8, yes, admission column.
Service is complete. Okay. Mr. Irshad. Petitioner. NK Devnath. PNRD, huh? 1. B. Chaudhary.
2, 3, and 5.
Standing Council BTC 2, 3, and 5. G. Bokulial. Sorry, M. Chetia. And Junior Government Advocate Assam for the respondent of 4 are present. In as per order dated. As per order dated. 8/9/2023 of the Law Jima Court, the service of notice upon the respondent number 6 is complete. As Mr. Chaudhary, Standing Council BTC, has paid for and is granted 2 weeks time to obtain the relevant records in view of his submission that he has not yet received the relevant records. List the case on.
Item number 35.
Yes, my lord. I may appeared on behalf of respondent for my private. I may be allowed to 4 weeks time to file affidavit in the police.
Today was
Oh, Bolai Champara.
Yes, ma'am.
Your case, there is another case. There is another case. J. Sharma, you want how much time?
4 weeks time, I will do.
My lord, today was fixed for some interim order also, my lord.
Now he has appeared. You are higher bidder or what?
I'm the highest bidder, man.
You are the highest.
Highest bidder.
His bid is lower.
I'm the second.
Second. And what ground you are challenging?
My lord, various anomalies.
Different documents indicating different as father. He's doubting your father's name, right?
Right.
And that apart,
And Baki Jai, that is serious.
Not
One.
serious, well.
Serious. one.
I'll
Produce your Baki Jai also. He has annexed perhaps. And who is for the fishery?
Mr. Sharma appeared. ma'am.
Sharma is found absent. J. Sharma, petitioner. M. Setia, 1. And Mr. N. Bora,
Mild.
learned counsel, has submitted that he has entered appearance on behalf of the respondent number 4 recently and has paid for 4 weeks time
Maybe 2 weeks, my lord.
3 weeks time to file counter affidavit on behalf of the respondent of Mr. P. Sharma, Lion Standing Counsel, AFDC, for respondent number 2 and 3 is found absent today on call. The prayer made by Mr. Bora is allowed. Is the case on.
My lord, the record may kindly be called for, my lord.
Sharma is not there.
Record will be required, my lord.
P. Sharma is not there today.
And the matter of interim, my lord, may be hard on the next day.
Lion Standing Counsel, AFDC,
My lord.
shall is to make endeavor to produce the legitimate records of settlement and or to file counter affidavit on before the next date of listing.
Interim
1610.
interim matter may be hard on the next day.
Prayer for interim relief. 7 years
Yes, my lord. My lord.
will be considered under returnable on the next date of listing.
Supplementary list for admission, item number 54.
Tinta.
Item number 55.
Lordship, item number 57, can it be taken after
Mr.
some time, my lord?
Mr.
R. Karim.
R.
Karim.
Karim, learned counsel for the petitioner, is present.
Can it be passed over for timing, my lord?
You have taken it by order. And have you seen the office note?
No, my lord.
In view of the office note dated 24/7/2023, await for the service report in respect of respondent number 3. Release the case after 2 weeks.
No problem.
For orders, item number 36 and.
Yes, Mr. P. Sharma, you obtained the records of the artist. P. Sharma likhi dibo. I got a P. Sharma likhi dibo standing now.
36 and 37.
Okay. Here, 36 is the contempt and 37 is the
Right.
writ petition now. In fact,
That petitioner died, right?
yes.
Petitioner died.
substituted by
Where is Mr. P. Varasaiji?
he is,
And secondly, Mr. Usami, where is the service upon the respondent number 3 in the writ petition? I think instead of this pursuing this contempt petition, we should have decided the writ petition itself.
In the writ petition, Mr.
I-
Bhattacharjee represent the municipality, but no affidavit is filed.
Right, we'll decide on the basis of available materials, but what about service of notice upon respondent number 3 in a writ petition? Who is this respondent number 3?
Respondent number 3, one Bedimuddin Sheikh.
What is his credential? Why he has been impleaded?
He was allotted to the totally participate in the tender process. It's not
There is
admitted.
no tender process according to you.
That is the statement in the
No, who is respondent number 3?
against who was now, my lord, holding that particular.
You have not gone through it. Go through the record. Respondent number 3 is served or not. We can decide a writ petition instead of
My lord, definitely.
the contempt petition about an interim order.
My lord,
You want the shop,
my lord,
we have to decide the writ petition.
definitely, my lord,
Find out whether respondent number 3, whether he is a relevant party,
my lord,
whether his presence is necessary,
my lord.
or otherwise we can strike off his name. We don't know who is he. And why should I bother?
Well, can you next week, my lord?
Next week, next Monday to Monday. List on the prayer of Mr. Mr. Ikwe Goswami, learned counsel for the petitioner, and Mr. D. You are in contempt or what?
I am in the petition, Lord. Performer.
Mr. D. Chaudhary, learned counsel for the respondent number
5. Performer.
5. Performer are present. Mr. P. Bhattacharjee, P.S. Bhattacharjee, learned counsel for the respondent municipal board,
My lord,
is found absent on call next Monday.
That will be holiday. That will be.
Lordship,
14. List the case 14.
I love that.
P.S. Bhattacharya, sir, on leg on another foot.
Okay, on the prayer of MS so-and-so, line counsel appearing from so-and-so, list the case on so.
Item number
Yes,
36
Bhattacharya.
and 39.
Yes, Khonigar.
But the considers pass the order, my lord.
Huh? In
contempt-
terms of the repetition,
It will.
R Ali, where is R Ali? Yes, writ petition direction has been complied with, that is what.
Mr. Arali is on lakes in court number 6.
Show it to him. If the writ petition direction, give a copy to him. We can close both the writ petition as well as review. Okay, after some time.
Item number 40.
Kindly pass over the matter for time being.
There is no time for passover all.
41.
Lordship, same. Where
We have,
41 or
we are considering the representation, Lordship. We have fixed for, I think, for a year, there is only disposal of some representation only. So we will dispose it of. There is nothing.
Leading counsel is not there.
42.
This is for substitution, Lordship, may I allow it?
But beyond time,
Please, Lordship.
there should be at least an application.
The application is there.
No seeking
Lordship,
condonation. Is it not? That formality is required to be followed. Thereafter, we will exercise your jurisdiction under 226. That is a different matter. But otherwise, Mr. Counsel,
Sir, myself is in another court.
on the prayer of Mr.
A. Hussain.
A. Hussain, learned counsel, if you heard the applicant leaves the case after 2 weeks. On 1 week.
43.
Apprise Mr. Mohan what formalities are required. Mr. B. Goswami, learned Additional Advocate General Assam, assisted by Mr. R. Kakoti, P. Kakoti, for the respondents are present
43.
after we. Mr.
MS Alam, service is complete.
M.
MS Alam.
M.S. Alam,
Yes, sir.
learned counsel for the petition. P. Das, you appear for whom?
BTC. On behalf of P. Nayak.
Any
Your
forest?
Lordship,
Any forest? Okay, P. Das, learned counsel,
5-6.
appearing for Mr. P. Nayak, learned standing counsel BTC for the respondent number 2, 3, 4.
No,
5,
Lordship,
6.
3, 4, 5, 6. And that
6.
principal forest is
And
Kanjabari.
G. Bokolial, learned counsel for the respondent number 7. Assistant Labor Commissioner. Oh, 5 and 7.
District আপোনালোকে,
P. Das লিখিব 3, 4,
3, 4,
6.
6.
Bokolial লিখিব 5 and 7.
DFO.
Huh? As per order dated 25/8/2023, the service of notice upon the respondent number 8
Service
is complete. Full stop. As the notices have been duly served upon all the respondents, office to list the case in the admission column after a week on a 2 weeks by the office. The interim order passed earlier shall continue till the next date of listing.
44.
Pertaining to the same matter, your Lordship.
Service complete.
নাম কেইটা চাই লব MS Mr. Alam, right?
Yes, Lordship.
Alam নে কিবা ক'লে নে? Alam. P. Das 3,
3,
4,
4,
6.
6.
Bokolial 5, 7. Lojima Court Order 25/8/2023. By Hineke. Respondent number 8.
45.
Interim order.
45, same matter. Subject matter.
Vedas 3, 4, 6, Pocolia 5 and 7, office note 25, 8, response number 8, admission column, interim order.
Deeply obliged.
46,
In this case, my lord, 36, 3006, my lord, notice was issued, my lord, wrongly.
Hmm?
My lord, respondent number 4, my lord. It should be, my lord, respondent number 5, my lord. Private respondent number 5.
Heard Mr. D. Gugui, counsel for the petitioner, and R. Gugui, standing counsel, Forest Department, for the respondents. Full stop. In the area of respondents, there are 5 respondents. Full stop. Respondent number 1 to 4, appearing for respondent number R. Gugui, standing counsel
Forest,
Forest.
person one.
for 1 to 4. Huh? Full stop. While issuing notice to the respondent, comma, by order dated 36/2023, comma, the petitioner was directed to take steps for service of notice on, quote, the respondent number 4, unquote, by registered post with AD. Full stop. Learned counsel for the learned counsel appearing for the parties have submitted that the notice ought to have been the direction ought to have been for service of notice upon the quote unquote respondent number 5, and full stop, as the respondent number as by order dated 36/2023, comma, no direction was made to the petitioner to take steps for service of notice upon the respondent number 5, comma, the petitioner has not been able to take steps for service of notice upon the respondent number 5, and the observations to that effect are recorded in the office notes. Full stop. The petitioner shall take steps for service of notice upon the respondent number 5 registered to with AD within 2 days from today, 2 working days. You have received the copies, extra copies?
Yes, the lordship will receive the
List the case after 4 weeks. Any interim order?
no interim order. Deeply obliged, lord.
7,
Zibora,
Here, Pishala.
Enkelib Nut, 1456. Anybody for
947.
respondent number 7? Mr.
Yes, ma'am.
Mr.
Yes, ma'am.
S. Ahmed. Are present. As per order date. '89, 2023. Come of the Lajima Court, the service of notice upon the respondent number 3 is complete. As the notices have been duly effected upon all the respondents, comma, service of notice, list the case in the admission column after a week on a date to be fixed by the office. Admission column.
58,
Take instructions.
In this matter, I am given to understand that Mr. K. Chaudhary had already addressed your lordship.
Has made some submission.
So the facts, perhaps your lordship are already aware. I won't trouble your lordship much on the facts. The facts are otherwise very simple, madam. I have been rejected on the only dispute is with regard to this, madam. Let me take your lordship to that page 23.
That day I asked a question fundamental, maybe out of curiosity.
And whether it is a state. My junior told me, I can straight away address your lordship on that. If your lordship kindly comes to the NIT, which your lordship will find at page 31. The NIT is floated by Indradhanush Gas. And Indradhanush Gas Grid Limited is your lordship will find at page 31. It is a joint venture of IOCL, ONGC, GAIL, Oil and NRL. All of these, as your lordship is aware, all of these are Government of India undertaking. In some, NRL, State of Assam also has a share. Now, the issue would be whether since it is a joint venture, and as has rightly fallen from your lordship, New Horizons, Supreme Court said that once it is a joint venture, it acquires a separate identity. So perhaps in that context, that question has fallen from your lordship.
No, many.
Whether-
Not single, not many. One. Oh, it is not a state.
That is what I was.
I'll come to that. You can explain it. It is not a public sector undertaking. Maybe IOCL, not Indradhanush.
Each of these constituents.
Right. Five are public sector undertaking, central public sector undertaking.
Precisely.
It is neither a government company as per companies law. And it is not a subsidiary of a government company. It is not a statutory body. It is purely registered under the provisions of the Companies Act, either 1956 or 2013. It is neither an arm of the government, extended arm, nor a state, nor an instrumentality of the state, nor a government company, nor a subsidiary of the government company. Now, in such situation, these five PSUs joining together, it is only a public limited company. Now tell me, this is my tentative view. This is my tentative view because suppose there are decisions, say Unit Trust of India was earlier a statutory body. By a repealing act, it has been changed. Now LIC, State Bank of India, General Insurance Corporation, Punjab National Bank, they have taken stakes, 25% each in UTI. Supreme Court has said this is a public limited company only. Neither of these, which I have said. There are other bodies. One company was formed, 16 public sector banks. There also it is found that it is not Article 12. Not Article 12. That is why I just asked the fundamental question. But this will be left open.
The
Yes, mister,
has not,
tell me, what is the color you are wearing?
It's a non-government company,
Non-government company, not a government
not
company,
a government. Lordship is
Pure and
carrying a
simple.
public limited company, not a government company,
normal government company.
not a government.
So whether it will take,
I mean, but,
otherwise it is in the, its functions are governed in the realm of private law. This
I
is
appreciate
my
it.
tentative view, subject to
I
correction.
appreciate what has fallen from your lord. My lord, firstly, this is,
No, if that is in affirmative, then this is not mandatory.
but I will address your lord straight away. And first thing, my lord, the technical thing that I would like to bring to your lordship's notice is this is not an objection raised either by Indradhanush itself or any of the respondents.
No, but we are assuming jurisdiction.
My lord,
No, nobody can raise that issue, but we can raise the issue
Sorry?
because we are exercising the jurisdiction.
Perfectly good. Now, if your lordship will kindly come back to that page 31.
Yes.
If your lordship sees each of these entities, if a writ petition is filed against IOCL or ONGC or GAIL or OIL or NRL, each of these writ petitions are maintained as being a state,
Instrumentality of the state.
instrumentality of the state. Now, they have got together, formed a joint venture. The purpose is, I will address your lordship on 3 because the tests of Article 14 have been laid down. Your lordship is aware, Ramanna Dayaram Shetty, thereafter Pradeep Biswas, and finally, my lord, it has been gone into in detail in the Z Telefilms case. I will place the judgment. What the purpose for which these 5 entities have got together is for laying of gas pipelines for the purpose of providing gas to the citizens. That is the purpose. The reason I pointed that out straight away is the tests are threefold. If you're watching, kindly have Z Telefilms for a moment. It is 2005, volume 4, SSC 649. And if your lordship kindly turns to para 18, I won't trouble your lordship with the entire discussion. The tests which originally were laid down in Ramanna and also in Pradeep Biswas have been summarized as para 18. These are the tests which will ultimately determine whether a writ would be maintainable or not. And in my respectful submission, my lord, this particular case would fall within 1, 4, and 5. May I read it? It is in the above context that the bench in Ramanna Dayaram Shetty laid down the parameters or guidelines for identifying a body as coming within the definition of other authorities in Article 12. They are as follows. Number 1. One thing is clear that if the entire share capital of the corporation is held by the government, it would go a long way towards indicating that the corporation is an instrumentality or agency of the government. If I may pause here for a moment, madam. Each of these entities, the share capital is held by the government. Each
No,
of these
entities, those entities.
those entities. So they have got together. So to that extent, it has the sanction of the government for these entities to come together and form a joint venture for a purpose. Now, serial number 4, if your lordship kindly comes, existence of deep and pervasive state control may afford an indication that the corporation is a state agency or an instrument. Now, all these public sector undertakings without a deep and pervasive control of the state, in this instant case, the Union of India, they could not have come together to form a joint venture. It would definitely have the sanction and approval of the government of India for coming together to form a joint venture. Now, the next one, Malad, this is all very important. If the functions of the corporation are of public importance and closely related to governmental functions, it would be a relevant factor in classifying the corporation as an instrumentality or agency of the government. So these are the 3 tests as laid down and which is still good law. My lord, these are the 3 tests which this entity would fulfill for your lordships to exercise, treat it to be a state or another authority under Article 12, and therefore maintain the writ.
That is my respectful submission so far as this.
So far, 1, 4, and 5.
Fine.
Out of 1, 4, and 5, I am not primarily agreeing with 1 and 4, maybe 5.
Well, 4 also, why I say 4 is without the sanction of the government, these entities individually could not have taken a unilateral decision to form a joint venture. So if that is something which only the records had it been a pleaded case, perhaps it would have been brought on record how it came together to form the joint venture. And I am, my lord, almost 100% convinced that without the sanction of the government of India, they could not have come together to form the joint venture. And that would
Seems to be
indicate,
that only 5, suppose
and one of them
some
is
public policy may be there. So far, I am testing 1 and 4. I am not satisfied because there are so many other decisions that these companies forming another company does not make it an instrumentality of the state. That is quite clear. I am quite convinced about 1, quite convinced about 4 also, because memorandum of association, it has memorandum of association and article association. I think Mr. Deka has. So 4, right. 5 could be that, yes, it might be a government of India policy to have gas connection, provide a provision for gas connection to citizens. It might be under 5 perhaps. We will not test further.
And-
We will not test further. We'll leave it open.
and the other thing I wanted to point out,
Otherwise, it is contract work is of no public importance. It is purely for their benefit.
particular contract,
Right. Boundary wall is not public.
that I will not stretch to
I'll
that.
leave it open, Mr. This issue, I'll leave it open. I'm not going into deeper into it, but maybe you have a mandate from the government of India that to provide this gas connection. Basically, your work, not boundary wall.
Not the boundary.
Basically, providing your entrusted with the duty to provide gas connection, right? Or lay down pipeline.
Pipelines and.
That could be, that could have a public character. We are not going to debate, but this issue I'll keep
And-
open.
Just for academic purposes, Madam, since your lordship has indicated, if your lordship sees paragraph 3 of Z Telefilm, paragraph 33 of Z Telefilm, there is a very interesting thing that has been said by the Supreme Court. Even if it is a private body, but it exercises public function.
Right. That is why I'm saying only 5.
Well.
That is why
Well,
this body may have a mandate to provide
Yes.
gas connections, which is of public nature. So it might have a public element.
Yes.
Otherwise, the providing pipeline.
Right.
And I also question that boundary wall is not a public character. It is for their get chamber or whatever. Anyway,
now, my lord,
so there is food for thought for
for future,
someone.
they can raise that objection in a later case. Now, my lord, if your lordship comes to the certificate, which I was pointing out, which is at page 23. If your lordship has page 23, right at the top, your lordship will kindly note this, Udyam registration certificate. This is the certificate. Now, type of enterprise, it says medium. Now, if your lordship kindly turns the page, your lordship will kindly note this, date of Udyam registration. It is 23/1/2021. This is the date of the registration. Now, my lord, they have rejected me on the basis of page 25. This is an annexure to the certificate. I will show how it is an annexure. Your lordship will kindly, right in the middle, there is a chart. Right in the middle of page 25. And that indicates 2 financial years, 2018-19 and 19-20, where the type of enterprise has been recorded as medium. Now they want to say, contend, that I have graduated to medium with effect from 18-19. So therefore, the 3 years will be over in
21-22. So therefore, I will not be entitled. That is the ground taken. If my lord will kindly take up my affidavit in reply that I have filed to the respondent number 2. I'm sorry, I'm told that it has not come on record. It was filed long back, my lord. On 13th itself, it was filed.
Affidavit by?
Affidavit in reply filed by us. To the
Yes, ma'am.
respondent number 2's affidavit.
It is not on record. No.
I have furnished an extra copy, my lord.
Yes,
If your lordship will kindly come to page 188, annexure A,
yes.
so this is the page on the web portal from which this certificate is downloaded. At the very top, your lordship will find 2 options given. One is print with annexure. At the very top of page 188. So if we click on print, only the certificate comes out. And when we print with annexure, that second document at page 25 also is generated. Now, my lord, in that page itself, 188, your lordship will kindly see that there is a ODM registration number, thereafter name of enterprise. Just after that, your lordship will find type of enterprise. And your lordship will see the classification is given. My entire classification till date, from start to finish. 2021, and your lordship will kindly see the classification date, 23/1/21. So this registering authority has treated my classification with effect from 23/1/21, and the relevant year is 2021. Now, in this context, if we test the,
Now, you say that this is 23 January 2021.
that is the date of the registration. So naturally,
So which year you were graduated to medium then?
this
2021,
2021,
then 21, 22, 22, 23.
3 years I get benefit under the notification. So I
So
will come within the 3 years when my tender
what was
was,
the last date? What was the last date of submission of it?
last date of submission of tender was, last date of submission was 16/5/23.
Out. Out.
No, in. It will be, if it is 2021,
3 years from the date.
3 years from the date. The
Yes,
date of
from the-
registration is, it will run up to 24/1. 23/1/2021,
You want to say that this
because the,
interpretation of that document,
yes. If your lordship will
page
kindly,
30,
your lordship will kindly
page 30,
first come to my lord, page 27.
basically you'll be relying upon page 30.
30 read with page 29, clauses, subclauses 3, 4, and 5 of clause 8. Your lordship will first come to 3, subclause 3. Based on, as my lord got it, page 29. Based on the information furnished or gathered from government sources, including ITR or GST return, the classification of the enterprise will be updated. Next, subclause 4. In case of graduation from a lower to a higher category or reverse graduation, sliding down to lower category of an enterprise, a communication will be sent to the enterprise about the change in the status. Next, subclause 5. In case of an upward change in terms of investment in plant and machinery or equipment or turnover or both, the consequent reclassification, an enterprise will maintain its prevailing status till expiry of 1 year from the close of the year of registration. Your lordship will kindly mark these last few words, from the close of the year of registration. Earlier, it was from the close of the year of registration. Now, if your lordship compares it with the amendment at page 30, same clause has been amended. There are 2 major amendments in this matter, I'll point out. In case of an upward change
in terms of investment in plant and machinery or equipment or turnover or both, the consequent reclassification, an enterprise shall continue to avail of all non-tax benefits of the category micro, small or medium. It was in before the reclassification for a period of 3 years. That is the first amendment. 1 year has been changed to 3 years. And next is very important. From the date of such upward change. So earlier it was the year that was the relevant period. Now it has become the date. So now the question is, what will be the relevant date? Now, if your lordship kindly comes back to subclause 4 of clause 8, what is the requirement? The moment there is a upward or downward change, there will be a communication by the authority to the enterprise concerned about the change in status. And that communication cannot be anything except the registration itself. So how does, because these are documents which are all auto-fetched from the IT department, from the GST department, because nowadays everything is available on the website. They auto-fetch it.
So on the date of moving the petition, we asked the Central Government Council also that what kind of procedure they follow.
They have come up with a very interesting thing. They have, if your lordship will kindly have the affidavit filed by respondent number 5, they say, in fact, it is the language employed seems to be contradicting itself. First, your lordship will kindly come to page 169. Subpara E, my lord. All the new so-and-so holder were advised to get migrated to the new system of ODM registration for reclassification. And accordingly, the enterprise got migrated UM small category to ODM registration reclassified as medium category on 23/1/21. So that is the date of the registration. But interestingly, they have come up with another very interesting, completely, they have gone on a tangent and come up with another aspect at page 170. They now want to say that it does not apply to works contracts at all.
170.
170. Subpara I. It is pertinent to mention that the public procurement policy for micro and small enterprise order 2012 does not apply to works contract.
That was also the submission of Mr.
Yes, that is the stand taken. So I will have to satisfy your lordship as to how it applies. Now, the first thing they say at subpara E is that the date is 23/1/21. So now that position is clarified by MSME. But in the same breath, at the next page, they say that it does not apply to works contract. Now, the answer to that, your lordship will kindly come to the NIT itself.
I have seen it. Their own tender document
Says. So therefore, Dr. Associates and
I have not taken that stand, my lord. Regarding non-applicability.
Mr. Chaudhary represented whom?
private party,
Private party. I thought that
private
it is
and
92.
I have not taken that stand, my lord. It was a mistake on our part. Actually, it is a works contract, my lord. We should have specified. It is a works contract. The policy does not apply, but we have given in our tender, my lord. So I am not taking
Your
that stand.
clause 40.1.
I am not taking that stand, my lord.
So
I am not taking this stand.
that is very fair on my learned friend's part, because they cannot escape having incorporated. Your lordship is the law is very clear. After Dr. Associates, whatever you have disclosed in the NIT, you cannot resort to some other criteria. Dr. Associates.
No, you've set the goalpost. Now you cannot move it from there.
Exactly.
Right, after the
We are
game
not
is
taking that
played.
stand. We have not
Because
taken-
I thought that Mr. Chaudhary was
No, no.
representing also you. But
Why?
that FAQ is gone. FAQ on by your own conscience, you have incorporated this clause 40.1. So that argument of
Ought not
Mr.
to have been,
Chaudhary
but
false.
that's a different aspect, my lord.
Huh?
Ought not to have been incorporated.
And that is different. But
That's different aspect.
once incorporated, you have set the goalpost. Now you cannot
Now I can-
rearrange it. That is for you. It is to follow.
But actually,
So
my lord,
We
under-
don't know about.
Under the policy, it is not entitled, my lord. We need to-
You have done it.
My lord.
You have done the
I'm
exercise
not done, I'm not done.
and consciously incorporated it as per Gazette of India dated 26/3/2012.
Clause 90 and
Okay, that
That point, I am not even troubling a lot.
I have not, I have seen it, so
So the only issue that remains.
you are not arguing as a tendering authority?
I cannot argue.
Then I won't trouble your lordship with the judgments. The only issue that remains now is what will be the relevant date.
3 years.
3 years from which date? Now, for that, my lord, we have to fall back on these three subclauses, subclause 3, 4, and 5 of rather 3 and 4 and the amended clause at page 30. Page 29 and 30 will clinch the issue.
Only thing is whether this is to be 8/4. 8/4, what kind of thing they have they addressed this issue in the affidavit?
No, the issue is they cannot come up with any other answer for the simple reason. The only mode of communication can be in the form of a registration certificate. And that registration certificate was admittedly issued on 23/1/2021. There is no other communication that can be brought on record. Like, for example, my lord, when I complete my LLB course and I make an application to the Bar Council of India, that issue me a registration, issue me a license to practice. They don't separately write a letter to me. All they do is they issue the license or the registration as an advocate. And it is from that date that I become a practicing advocate. Prior to that, I might have the qualification. I might be a LLB. Let us assume I have appeared in the exams in June. I have passed in September. But if the license is issued in next March, my effective date will be from March.
But page 25, 1819 or 1920, page 25. So this is your self declaration.
No, this is autofetch. If I may place the document, if your lordship will kindly come to page. If your lordship will kindly come back to that affidavit for a moment, my lord, which I had placed. Affidavit in reply to respondent number 2's affidavit. At page 191. Nowadays, things have become so transparent. All the data are in the Income Tax Department's website, web portal, GST web portal. And this is how it is done, Manoj. If your lordship straight away comes to clause 4 of page 191. For example, for filing on ODM portal, the financial year 2021, the data of 1819 in respect of investment and turnover from IT department and GST were fetched, auto-populated to avoid any deviation dispute in such data and may affect the MSME classification. This has been adopted due to the following reasons, and they explain as to why it has been done.
Right.
For the financial year 1819, the time of filing of IT return was July 2019, and the time may be required for further processing. In the case of companies, enterprises, the accounts gets audited and completed by October or November 2019. Also, the process of GST return for the financial year 1819 follows similar timeline. Hence, frozen data of 1819 has been considered for MSME registration and classification during the year 2020. So these are highly technical things, which we don't understand, but this is how it is done. They are all auto-fetched from the respective portals of the Income Tax Department and the GST Department, and accordingly classifications are made. And for whatever be the reason, the one and only communication is in the form of the registration, which was issued on 23/1/2020. That is why, my lord, I pointed out from that very affidavit, if your lordship even today goes to the web portal and checks out my registration.
1 minute, page 191. Because this is the issue, perhaps that is why the clarification is. is brought to the notice.
And this perhaps also happened because of the fact that that was the period of COVID.
Where is the amendment?
Amendment is at
see.
page 31. In fact, I was coming to that for another reason. If your lordship, my lord, compares the earlier clause 5 with the amended clause 5, your lordship will find a noticeable difference. Earlier it was the year of registration. Now it is the date of upward change. Now if your lordship has page 30 and page 25 simultaneously,
Page 30.
page 30 is the amendment. And if your lordship comes back to that annexure, which shows 1819 as medium, your lordship will find that I will be left without a date. It will be only the year. From the date of such upward change. Now, if we say it is 1819, I am without a date.
Now come to clause 3, subclause 3.
My lord.
There are two modes.
Based on the information furnished
This is one,
or gathered,
or gathered from the government sources.
including ITR or
ITR.
GST.
Now here, if page 25 is looked into,
My lord.
then this is based on ITR.
Right.
Information could be furnished by the applicant, or as you have said, this clarification, it could be gathered from the government sources,
Right.
including ITR.
Right.
Or GST return. The classification of the enterprise will be updated.
Right.
So this page 25
Right.
is based on your ITR return furnished from your side or from
No,
the government side?
They have my instruction is that they have auto vested from the department.
Then come to page 27.
I'm sorry, madam.
27.
27.
Classification of enterprise 1, clause 1.
Right.
Investment in plant and machinery, 1 crore. Turnover, 5 crore.
Ah.
Small, micro.
Ah.
Small is investment in plant and machinery, 10 crore. Turnover, if it is below 50 crore,
Small.
small. And if plant and machinery, it is below 50 crore, medium.
And
And turnover is 250 crore.
Right.
Now, come to clause 3. Subclause 2. If an enterprise crosses the ceiling limits specified for its present category in either of the two criteria of investment or turnover, it will cease to exist in that category.
One.
So what is to be what interpretation?
But my lord, this was, when this was inserted, it was the relevant period was the year of registration. Now it stood amended subsequently. Everything else remained the same, but subclause 5 was amended on 18th October 2022. And this says, from the date of the availability of the benefit will be, it does not matter when a party got upgraded from micro to small or small to medium. What it says is this benefit of 3 years will percolate to that party from the date of such upward change. Now, what will be the date? The question before your lordship is, what date will your lordship assign to the petitioner company for the purpose of counting the benefit of 3 years? That date has to be ultimately decided. A conscious amendment was made by the authorities from year of registration to date of upward change. Now, some date has to be assigned, assuming that date of 23/1, 21, we forget it for a moment. What will be my date? I will be left without a date.
Because that ceasing clause.
My lord, that has to be again read with some.
Yes, all these are to be read together. Nothing is concrete. Nothing is concrete. Otherwise, you
That is
not
why
having
we have
litigation.
My lord, in fact, my lord, as an alternative argument, we have also taken up that position that our bona fide understanding was that we will get the benefit. That is why we did not submit. We have taken it on affidavit that if the interpretation is that we were no longer small and we had become a medium, had there been clarity, we would have deposited the EMD, and even today we are agreeable. We have put it on affidavit saying that we are agreeable to deposit that EMD. If my lord, 3 sets of lawyers and this honorable court is unable to conclusively say that this is the date, it is.
Everything is said by Government of India. Upward charge cease to be in that enterprise, and their affidavit is falling short of the requirement.
And my lord will otherwise everything would have fallen into place had that amendment not come. Had they even retained that portion from the close of the year of registration, then perhaps that confusion would not have arisen. They could have treated it as 1819 and rejected me. But the moment they made a conscious amendment saying that from the date of such upward change, what will be the date?
Who has filed this?
And there is, my lord, another aspect that I wanted to draw your lordship's legal proposition, my lord. If your lordship so permits me. This is in the context of clause 4, subclause 4. If your lordship sees the language, what does it say? In case of graduation from a lower to a higher category, or reverse graduation sliding down to lower category of an enterprise, a communication will be sent to the enterprise about the change in the status. So now here is a requirement on the part of the authorities to communicate to the concerned enterprise that your status has been changed.
That is what we
The
thought
reason
about
is,
it on the,
the reason is, my lord, your lordship recalls the judgment in Bachittar Singh. What did the Supreme Court say? That you might have done something in your file. Unless you issue an order, it has no relevance. And that this particular subclause 4, and that law has not since then become very clear, my lord. Bachittar Singh has been consistently followed by the Apex Court, and I can place one of the recent judgments, 2010 to this. If your lordship will kindly take up 2010, volume 9, SCC 157. This is a Greater Mohali Area Development Authority. What is the requirement of issuing a formal order and communicating is recorded in paragraph 22 to 24 at page 164. Has my lord got it? The constitution benches of this court in Bachittar Singh versus State of Punjab and State of Punjab versus Amar Singh Harika have held that an order does not become effective unless it is published and communicated to the person concerned. Before the communication, the order cannot be regarded as anything more than provisional in character. A similar view has been reiterated in Union of India versus etc. etc. In Lakshminarayan so-and-so, this court held that the order of the authority must be communicated for conferring an enforceable right. And in case the order has been passed and not communicated, it does not create any legal right in favor of the party. Thus, in view of the above, it can be held that if an order is passed but not communicated to the party concerned, it does not create any legal right which can be enforced through the court of law, as it does not become effective till it is communicated. Assuming they feel, based on my IT returns and GST returns, they feel that I have graduated. Let us assume the reverse. I have graduated from, I have come down, slid down from medium to small. I might be entitled to some extra benefits. If it is not communicated to me, how do I avail of those benefits? So therefore, in the context of these judgments also, in my respectful submission, subclauses 4 and the amended clause 5 have to be read together to mean that the relevant date will be 23/1/2021.
what was your earlier registration?
It is at page 22, my lord. Earlier I was small. And ultimately, my lord, these are all beneficial legislation. So your lordship is aware, my lord, the interpretation in such legislations has to be the widest possible interpretation so that the benefit actually percolates.
Now, when you register yourself with Udyam or whatever,
Mal.
as medium,
Mal.
can you see page 23?
23, my lord.
This type of enterprise,
My lord.
medium, and within bracket, medium during previous financial year.
My lord. Even then,
Then, if you are in medium in the previous financial year, and when this new Udram came into being, whether it is an upward charge,
I became assuming on 23/1/21, they have issued the certificate and they say within bracket, medium during the previous financial year. What is the date of issuance of the certificate? It is 23/1/2021.
so that is why I am asking you whether, because you were medium earlier,
Yes,
earlier previous financial year, whether this is an upward charge.
it would the difficulty why it arises is this, my lord. It is when this notification, when this certificate was issued, it was the previous notification, unamended notification that was enforced. Now, the amended notification came on, your lordship will kindly see the date of the notification. It was after I was issued the registration. It is 18th of October 2022. And now the amendment makes this huge shift from year of registration to date of upward change. So some date has to be assigned to me. After this, I am assuming, my lord, we forget this date 23/1/2021 for a moment. What will be that date under clause, amended clause 5 for me? I will be left without any date. Assuming I accept the.
They have left many spaces. They have left many spaces.
So therefore, my lord,
What to do?
just to show our bona fide, what we have said in the affidavit is this one. Page 184 of the affidavit, same affidavit if your lordship will kindly. That is why I was pointing out to your lordship, my lord. 3-4 sets of lawyers and your lordship, we have been debating this for such a long time. So it was, I had a bona fide belief that I am not required. But if your lordship will kindly come to page 184, the subparagraph in that matter. The petitioners further humbly beg to submit that the facts and circumstances involved in the instant case reveal the ground on which the petitioner number 1 bid has been rejected is a hypertechnical ground and which is based on a pure question of interpretation of the relevant clauses of the notifications dated so and so and so and so. The petitioner were and still are under a bona fide belief that the interpretation of the said notifications so adopted by the petitioners is in fact the correct one, and consequently, the ground on which its bid has been rejected is illegal, perverse, irrational, and untenable. However, without prejudice to the interpretation adopted by the petitioner, they respectfully beg to submit that they are agreeable to deposit the EMD even at this stage. We still believe that the interpretation we have adopted is the correct one, but if it is, that is the only technical thing, and your lordship is aware, in Poddar Steel, there was a demand draft which was required to be submitted, something else was submitted, and the apex court said that this is a technical
So had they made it very clear that we will take the year of registration and not the year of upward change and not the date of registration.
Podar situation has been changed now.
Even then, my lord, that principle of mandatory condition and directory condition still remains one. And if your lordship kindly sees clause 40.2, what your lordship will notice is they have extracted it verbatim. Page 92. They have extracted the amendment verbatim in italics at page 190. And this says from the date of such upward change.
What is their affidavit? What is their affidavit?
Their affidavit, they are reiterating their ground of rejection. They are saying that that is how they have interpreted it. And ultimately, it all boils down to their interpretation. They say that our own documents reflect that we had graduated to medium in 1819. So therefore, they have rejected. And I am not attributing any malafide as such. The other aspect your lordship will kindly take note of, there is a difference of 2.23 crores. Now that the financial bids have been opened, there is a difference of 2.23 crores, which the government, Indradhanush stands to save. Yes, it is.
Yes.
But just one judgment on this issue. How price also has a relevance. I'm not troubling your lordship. This is a division bench of our High Court, 2006, volume 2, GLT 775. It's that Educom Solutions matter. And if I remember correctly, this was argued by none less than Mr. Soli Sarabji. (2006) volume 2, GLT 775, and the relevance of price is discussed at para 50. Here also there was a rejection, and our division bench held that it does a substantial difference in price does entail public money and therefore public income.
Para 15.
Para 50. The issue has been framed whether the lowest bid is a valid criteria to be taken into consideration or not. It is true that in Ronak International, Air India, Master Marine, Metacaf, the Supreme Court held that the price need not always be the sole criteria for awarding a contract. It is free to grant any relaxation or for bona fide reasons if the tender conditions permit such relaxation. That at the same time, the courts may have to bear in mind that the state and its agencies do not have unlimited financial resources at their command. Therefore, they altogether cannot ignore the lowest bid offers, though it itself may not be the sole criteria for awarding the contract. The margin of difference between commercial bid offered by the petitioners and the court respondent runs into few crores. It is one of the factors that should have taken into consideration by the decision makers, particularly in the context of there being no dispute about the validity and eligibility of technical bid offered by the petitioners. It is not a case where the technical bid offered by the petitioners were found to be ineligible. There is no dispute whatsoever that the petitioner's technical bid on the evaluation was found to be eligible along with the technical bid offered by the court respondent. It is a matter where applying hidden criteria, the state agencies have awarded more number of marks to the fourth respondent so far as the technical bid of the offered by it is concerned for whatsoever reason. Having regard to the huge margin of difference
It
between
was after opening of technical.
after opening, my lord, what I am trying to, the reason I place this is that price may not be the sole criteria, but it certainly is a relevant criteria. And here, my lord, if the interpretation that we have adopted, which is not altogether an interpretation which needs to be thrown into a dustbin, if that be the situation, price will definitely have it might amount to a hidden criteria being adopted by the authorities while rejecting, because they verbatim quote the clause at 40.2. And that clause says, it does not say year of registration, it says date of registration. If that be the situation, let us assume for a moment, my lord, at the cost of repetition, let us assume for a moment that 23-1-2021 is not
What,
needed.
what kind of, is there any interpretation in the act itself? Date?
No.
Who represents respond number 1?
It will be yes.
Yes, Mr. Roy, you're, because I think you were there on the first day itself.
Yes.
I have asked, I think if I remember correctly, I have asked the date.
Yes.
To the, not to you, to the CGC.
That day, he was not there.
Who were there?
Gogoi was there.
Because I have asked specifically, what is this date?
Date of lordship. To that effect, lordship, let me have 1 day time, lordship. If there is any communication, lordship. in
Because
terms of-
it is you who has put this
Lordship,
and everybody is in quandary.
lordship.
And I have asked the first day itself that CGC please clarify. Your affidavit is neither here, neither there.
Not there, lordship.
Is it not?
Yes, lord.
So what kind of date? What you have interpreted in your,
Lordship, to that effect, lordship, I have seen, lordship.
because it is date.
Lordship. In clause 5 also there.
In
lordship.
clause E, they admit, my lord, that the date is 23-1-21. If your lordship sees the respond number 5 affidavit, which I read out, they say that the date is
No,
They
lordship,
have said migrated.
migrating. Lordship, our, it was, all the EM holder were advised to get migrated to the new system
Hmm.
of Udyam registration for reclassification, and accordingly the enterprise got migrated from to Udyam on so and so. Thereafter, lordship, the system of Udyam registration dynamic in nature and based on the date of investment, data of investment and turnover, the status of the enterprise get updated, either graduate or reverse graduate from the existing status on the year-to-year basis.
The and what is your interpretation first thing? Come to page 170.
Lordship.
The fact is that graduation from one status to another level should have been in Udyam system only,
Lordship.
not from UAM to
UAM was
Udyam.
the-
That means what? What?
UAM was the earlier version.
Right.
Where the registration took place. Now it became dynamic. We have asked them to convert to the Udyam registration. Earlier it was UAM, now it is Udyam.
Udyam.
Lordship.
So, no, graduation from one status to another level
Lordship.
should have been in Udyam system only and not from Udyam to UAM to Udyam. What does it mean? See, from UAM to Udyam, the petitioner has graduated from small to medium. Right. But in Udyam, it has not graduated from one level to another.
It cannot because it was not in existence. Udyam was not in existence at all.
At that time.
Right. So what does it mean actually? See, he is putting up one interpretation. Mr. Indradhanus is putting up one interpretation. Now you are the author of this, and everything is dependent on it.
Lordship, let it be on Monday, Lordship, because
Why
of
should
the-
we?
I will just get the information whether.
See,
when
and
it
your
is-
document
Lordship,
also capable of two interpretation.
Lordship, I've seen that.
Is capable of two interpretation, both the interpretation. And if I put an interpretation in a particular tender document, tender issue,
Then-
everything will get haywire. Mr. Chaudhary, it is not your boundary wall tender. If I put an interpretation somewhere,
It will have an effect on others. also.
everything will
And
not
it will-
for this boundary wall of Indradhanus. If I say this has to be interpreted in this manner, everything goes.
It will affect all the registered enterprises.
Right. That is why I am
Lordship,
finding it difficult, not for boundary wall of Indradhanus.
others are.
It is not, Mr. Deka, it is not such an important matter of boundary wall only.
It is.
If I go on interpreting this, because it is the best authority who can say highest body.
Can I make my submission, sir?
I do not want to interpret this particular document because petitioner is there, everybody will get affected.
That is there, Manu, but just to make, I'll point out certain things from the amendment, Manu. Now, everything has happened, Manu. Why? Because of this transfer from one system to another, Manu. Lordship has seen the petitioner's earlier registration. It was under Udyog Aadhaar, Manu. Page 22, Manu. Now, they are to register themselves under Udyam, Manu. Now, the notification is at page 27. Because what is important, my lord, my learned friend has rightly submitted, my lord, it is a beneficial legislation. Now, to whom should the benefit percolate? To those who are actually entitled under the Act. It is the criteria for fixing a medium or a small enterprise is the turnover and income, my lord. Lordship has seen clause 3(2). The moment you cross that, you upgrade to the higher version, my lord. Now, the difficulty, Lordship will kindly come to 7, my lord. Page 28, my lord. And Lordship will also kindly have this book, the Act, my lord. Lordship will kindly come to 28, my lord.
Mr. Deka, it is your own creation, 40.1. It is your own creation, not anybody's creation.
It has come from the Act, the
No,
amended, my lord.
works contract is outside the purview. It is your own creation, not anybody else's creation, neither Mr. So, neither so and so. You have put it there. Works contract is under the purview.
I have to defend it, my lord.
No, you cannot defend it also.
My lord, 7. No, my lord, the clause, page 28. If your lordship, no, if your lordship can, the clause is available there also. It is, if the lordship is having the same book, it is at page 45, my lord. Starts at page 45, it is at 49, clause 7. All existing enterprises registered under EM Part 1, Part 2 or UM shall register again on Udyam on or after the first day of July 2020. All enterprises registered till 30th of June shall be reclassified in accordance with this notification. The existing enterprises registered prior to 30th of June shall continue to be valid only up to a period of 30th of June. Now, Lordship takes this date and Lordship takes page 28. of the writ petition. This date has been extended from time to time. That is why, my lord, the date of upward revision assumes importance, my lord.
Hmm?
Lordship will kindly take up page 28 of the writ petition. 28. 28 and 29, my lord. 28. Clause 3(7) at the bottom, my lord. The existing enterprises registered prior to 30th of June shall continue to be valid only for a period up to 31st of March 2021. Now, this has been further extended up to 30th of June.
Where from?
From the book, my lord, page 49. If your lordship sees at the bottom, my lord, it is substituted by SO number so and so dated 6 May 2022 for 31st of March 22 earlier. It was substituted from 19 January for 31st December and by SO number so and so 16th for 31st day of March. So first it was 31st of March, then extended to December, then from 31st of March 2022 and then to June 2024. So, my lord, if a entity, my lord,
I'm not understanding. Subsection 3 of section 7.
subsection 7 requires everyone who is registered under Udyog to re-register under Udyam. Am I clear, my lord?
Yes.
New enterprises will definitely come under with Udyam, but whatever was there with Udyog, but they have to re-register. Now, clause 3 says that the existing enterprises registered prior to June 30th. So the petitioner has registered prior to June 30th, 2020 under the Udyog, my lord, shall continue to be valid only for a period up to 31st March 2021. So he has to register in the Udyam portal prior to 31st of March 2021, my lord.
I am having a book up to 31st day of 2022.
31st June.
No,
June.
31st. See, you are reading.
Yes.
Right.
This is the latest one, my lord. It is
This-
30th of June, my lord.
Up to
30th of June 2022.
30th of June.
June 22.
Yes.
So from time to time, that has been extended. So, my lord, my respectful submission is this one. Admittedly, the petitioners from the ITRs or whatever, my lord, the documents furnished by them in the portal, in 2018-19, they have been reclassified as medium. They have crossed the benchmark of small. So now they delay in registration, in the registration till 2022. So can they claim the benefit from 2022 till another 3 years, my lord? That is not the object of the act. That is why the year of registration has been changed to date of upward revision. You upgrade to a medium in 2018-19 itself. The date 23-1, which my learned friend has placed, is the date of registration, my lord, not the date of upgradation. Date of upgradation is 2018-19. The moment you cross the ceiling, you are no longer a small enterprise. You are a medium enterprise. That is why that clarification, my lord, at page 190. Clarification dated 28-9.
One.
191.
191 means,
It is part of their affidavit, my lord.
or this one. It has not come yet. Anyway.
It is there in page 166 also.
One minute.
It is part of the private respondent's affidavit.
Yes,
So this notification clearly says, my lord, that what procedure has been adopted, how to rate a particular, grade a particular entity, my lord. The reasons are given in clause 4, why it has been done, my lord. For example, for filing on Udyam portal, the financial year 2021, the data of 2018-19 in respect of investment and turnover from the IT department and GSTN were fetched, auto-populated to avoid any deviation dispute in such data that may affect the MSME classification. This has been adopted due to the following reason. The reasons are given, my lord. Now to point number 5, to summarize, the following procedure has been adopted in relation to data autofill fetched in the Udyam registration portal with effect from 1/7/2020 onwards. For the financial year 2021, the data of 2018-19 has been taken.
so tell me, what is the date of upward charts? They are defining it.
They are defining it.
He is defining it. You are defining it. Right?
No, my lord, I am not
This,
defining it.
after this amendment, subparagraph 5 of paragraph 8, no other in document, this upward charge,
Upward change, I think.
change.
Change, my lord. Upward
Now,
change.
What is the date? That is the only.
Upward change, my lord. Page 29.
right? Upward change.
Change.
Who has defined it?
It is the Union of India, my lord.
Where?
This upward change is the date on which your investment will cross, my lord. Because that has to be read again
See,
with clause 3, my lord.
Page 30 is there. In case of an upward change, I could understand.
My lord.
In terms of investment in plant and machinery or so and so, and consequent reclassification. To that extent, okay.
And 3(2).
An enterprise shall continue to avail of all tax benefits of the category micro, small or medium. It was in before the reclassification for a period of 3 years from the date of such upward change.
Can I take your lordships to page 27? So this is the date on which the notification comes, my lord, 26/6/2020. 26/6/2020 requires everyone to now change from Udyog to Udyam. Clause 7 says how you are to change. Clause 7 puts an outer limit, my lord. That by 31st of March 2021, you will have to change to Udyam. But if you have upgraded, say from small to medium, you will continue to enjoy the benefits of medium, of small, till expiry of 1 year from the end of the registration. So if you register on 23rd of January 2021, my lord, as per this notification, you will continue till the end of the financial year, that is 2022, my lord, the next year. 31st of December 2021, you will continue to get the benefit. So now this last date of 31st of March has been extended from time to time. That is the reason, my lord, in my humble understanding, this notification was brought in to limit it till 3 years from the date of upward change. Lordship says, my lord, if the petitioner now, he does not register in January, let us take a situation, my lord. He waits, the time is extended from time to time. He waits till 30th of June 2020 to register himself. But he is a medium enterprise from 2018-19. If the interpretation of the petitioner is to be accepted, my lord, then he will get the benefit of being a small enterprise till 2025, my lord.
No, it's a Decca, one thing, one more thing. So far, so good, it was all right. Now this one, whatever, 166. That you have just somewhere.
166.
166.
This is the affidavit of the private respondent, my lord.
166. Somewhere you have read something here. Just clarification. This has come in
2021.
21. Now, this man is saying, now that page 25 is created on 23/1/2021.
Yes.
Right. Now, there were some confusions. Everybody was asking for clarification. This man has issued this clarification. Right.
Right.
Now he is saying how they fetch data from here, there, meaning thereby, by following this procedure, they has created this page 25.
Yes.
Right? Then when the petitioner or any other bidder know that they have made upward charge,
They are entitled to know it is their ITR, my lord. Don't I know how much I earned, my lord?
no, don't
Lordship
say
will
that,
kindly come
because
to page
they
25.
have to be recognized
My
also.
lord, let us come to page 25.
If you make such kind of submission, it is
Let us come to
not,
page
it will
25.
not be appreciated. I am asking you that how the they have to know their status also,
Exactly.
right?
will kindly
This
come to
now,
page-
this has created more confusion now.
It has created.
I was of the
confusion. I
idea
agree, my
that
lord.
this
It
ITRs,
has created confusion, my lord. Lordship will kindly come to 23. Because this is the document before us, my lord, while taking the decision, my lord. Page 23 at the very beginning, what does it say, my lord? Type of enterprise medium. Medium during previous financial year.
I have understood.
This is before
I
us,
am
my
not
lord.
saying, Mr. Dekka, that you have taken a wrong decision.
No, but
You
the
have
decision-
whatever is available with you, you have taken a wrong decision. And now they are taking shelter of some government notifications, right?
My lord.
Had it been their private documents, they could have been thrown out easily.
Another
Now,
document-
this interpretation, which is date of upward charge, because this has created more confusion.
Exactly.
Page 166, they have said they were fetching, see this bold, for the financial year 2018-19, the timeline for so and so, and they have frozen data, all these things they have created, and they have said this kind of example. Now that document was created on 23/1/2021. This document, page 23.
This is
And-
their registration. They have submitted
No,
before the portal.
the system they have
System will
put,
generate.
their system,
As
this
I
government of India had put. Not your creation. I'm not saying that your
No,
creation.
no, I'm not saying that.
It is MSME had put in the
MSME.
creation, and they have put what is nowadays called algorithm or something like that there, and they have created this document.
Correct.
Now, page 166, they have clarified what algorithm they have put in the system.
Yes.
From there, it appears that they have fetched ITRs and all from everywhere, frozen, which were earlier frozen. So, unless Mr. Day says, your interpretation is okay, his interpretation is also okay. I'm not saying that, but something if I write that is difficult. If
Exactly.
Mr.
Just prior to that, just one more document I want to show your lordship. No, page 153. ma'am. Although this is subsequent to the tender process, ma'am, we have sought clarifications from the DIC, my lord.
I have seen,
Lordship has
I have
seen.
marked it. He is also saying here and there.
He's saying.
I don't know whether he has the knowledge or not.
No, because under the.
Not the authority, he's not the
He's not-
He is not the authority, may not be, my lord, but under clause. Under clause, page 29, my lord, he is the district industry centers will also act as a single window, my lord.
Huh?
Clause 9, subclause 2. So he is not a
He's
nobody. my
a
lord.
messenger, basically.
He is not a nobody, my lord.
He is a messenger. He is a messenger, Mr. They. You
Let
can,
them file it in the form of an affidavit. Otherwise, we will be taken by surprise. Man. Let them file a short affidavit. Let them clarify the position on record. Otherwise, I don't know, they will suddenly come up with some instruction and I'll be caught by surprise. Let it be, instead of Monday, let it be on Wednesday. Man. By Monday, let them file an affidavit. Because ultimately, this will have
this
far-reaching consequences.
166 you now here brought, that is another creation. Now, there is question of date of creation also comes in. Because he is saying what 166 he is saying, see what he is saying. It appears in bold. For example, see 4. For example, for filing on Uddam portal, financial year 2020-21, the data of 2018-19 in respect of investment and turnover from the IT department and GSTN department were fetched, auto-populated to avoid any deviation dispute in such data that may affect MSME classification. This has been adopted due to following reason. See, process of GST return for the financial year 2018-19 follows similar timeline. Something like happened. Hence, frozen data. Mr. Deka, please see. Frozen data of 2018-19 has been considered for MSME registration and classification during the year 2020-21. So, his data was frozen in 2018-19.
Yes.
In that case, if everything is frozen there, 2018-19, up to 2020-21, then it will be some might prejudice, I don't know.
If it is frozen, my lord, it is obviously not communicated to me.
No,
If it is not communicated, how?
Lordship will read it again, my lord. Also, the process of GST return for the financial year 2019 follows similar. Hence, frozen data. Frozen data means, my lord, whatever data is already there in the income tax portal or the GST portal, my lord. Because as individual, my lord, I have filed my ITR, my lord, for the previous year or the year previous to that, my lord.
Read the first line also.
That data is frozen there, my lord.
Read the first line.
My lord.
For the financial year 2018-19, the timeline for filing IT returns was July 2019.
Yes.
And time may be required for further processing. So meaning that it was may not be
Time is
completed.
My lordship will read the next
In case of companies, enterprises,
the accounts gets audited.
and completed by October, November 2019. Also, the process of GST return for the financial so follow similar.
Time.
Hence, frozen data.
So if I'm permitted, my lord.
I am not an IT expert. Please
My lord,
tell
if
me.
I'm permitted. So for the year 18-19, whatever ITR return is to be filed, either by an individual or a company, that is completed by November 2019. That is what the letter says. For maybe for someone it is July 2019. For companies it gets audited, so it is 2019. That is speaking about the income tax law, my lord. So by November 2019, whatever data is required to be filed is filed for the company. Also, the process of GST return for the financial year 18-19 follows similar timelines. So by November 2019, GST returns, income tax returns are all filed. As I understand, my lord, subject to what your lordship says, my lord.
No, I am saying in clear terms. I do not understand.
My lord.
Frozen data.
Frozen
who is
data,
that?
as I would understand, my lord, frozen data of 2018-19 means whatever data has been furnished by the parties, submitted before the GST authorities and the income tax authorities, but that cannot be changed now, has been considered for MSME registration.
Right. And classification.
And classification during the year
That is
2021.
what? Then that is his 23-1-2021.
21.
So that got created in 2020 and 2021.
Exactly.
his 1819 and 1920, all those things that his status is medium on those 2 years has been revealed on 23/1/2021.
That is one way of looking at it. But
One way, I'm
one
not
way.
saying I'm,
One way of
so,
looking at it. Another thing, my lord.
so because I thought, initially I was of the idea, tentative idea that these ITRs have been filed by every SSC, and that is why in page 24, page 25, extreme right, ITR 356,
Yes.
all those are reflected because he has the
No, He
duty,
has not separately filed. It has been fetched from the system. which is
right?
what Vikas said.
Otherwise, see 3.2, 4.1,
Lordship is
the
reading from?
page 27. Calculation of
27.
investment in plane and machinery or so and so will be linked to the income tax return,
Yes.
right? Of the previous year filed under the Income Tax Act.
Income tax.
And he is saying now 166, they are fetching. They are fetching it.
The system is fetching, but basically the
basically-
MSME authorities will fetch.
So this reflection in page 25 is because of the act on the part of the MSME
System,
ministry system
System.
put by MSME
Yes,
ministry,
Yes.
and things came to be revealed in 2021. If it is revealed, you can say something on that, that it is revealed everywhere from 2018-19, end of the matter. End of the matter.
Because here, if we come, my lord, if we see
Page 25, this
page 25,
18, this row, investment in plant and machinery or equipment in rupees,
if your lordship sees 2018-29, is ITR file, lordship sees that column in the middle portion,
page.
page 25.
Hmm.
For the year 2018-19,
Hmm.
medium, so and so, last value is ITR file, it is no.
Even if
So
we,
who put this data? my lord? That is
even if,
another question.
even if, okay, 2019-20 also, we
Yes.
take into account that it is reflected in 2019-20, he's out.
This is my respectful
Let
submission
us
is-
forget to 18-19.
Let us forget, madam. Now, 2019-20, when he is filing the ITRs, my lord, he knows what is the income. Because this net income, which is showing, my lord, 26 crores net investment in plant and machinery or equipment, 26 crores in the middle portion, my lord. Now, this data, the MSME has not provided, my lord. This data has been provided by the petitioner while filing his ITRs, my lord.
ITR, and that is to be fetched.
That is to be fetched. So this data, he cannot say that I do not know what is my investment in plant and machinery. He cannot say that only in 2021, on the date of my registration, I have come to know that I have crossed the ceiling, my lord.
Yes, that.
Because
that-
as an individual, my lord, can I say tomorrow that I do not know what ITR I have filed previous year?
Yes, that is why that difficulty is that one is you are aware
Exactly, my lord.
and one is granted the recognition as such.
So 23-1 is the, my lord, date of registration. Date of upgradation is 2019-20 or 2018-19. That is my respectful submission.
Right, submission,
And what
respectful
is- what
submission,
is-
I should be subsection and Mr. SSY date of upward charge.
And what is before me while considering the bid is this, my lord. And regarding the price bid, what my learned friend has submitted regarding the offer.
No, price bid,
No,
when a case of technical
Yes,
bid is.
if your lordship is, because the rejection was communicated on 17/7 and the writ petition is filed on 28/7 after the price bid is opened.
That is when I know that I have quoted a much lesser rate. Otherwise, how would I even know? Why would I even
Please
file
come
a?
this side. Both sides have two interpretations.
Just to give a quick reply, quick example to what my learned friend said. Tomorrow, assuming a hypothetical situation, this honorable court, the honorable Chief Justice on the administrative side frames a parameter saying that if an advocate, nowadays all judgments are uploaded, all reported judgments are available online, we will auto fetch, and any advocate who has 100 reported judgments, he will be entitled to the benefit of becoming a senior advocate. I, as an advocate, might know that I have more than 100 reported judgments. Will I automatically become a senior advocate till it is conferred on me? That is the test.
See, Mr. Roy, there are two things. 18, 19, 19, 20, evidently, they crossed the limit from small to medium
In terms of.
investment, whatever.
Lordship,
And your Uddam and Udhar, something like that.
Lordship.
One is
UAM and Udyam.
one is Uddug Adhar. Second is Uddam. Right.
Lordship.
Now you have shifted to this Uddam system.
Right.
In 2000, maybe 20, 21.
21.
Now, so far so good, till page 29. Now page 30.
30.
Only thing is this.
Lordship.
Page 29, up to page 29 it is okay. Last date of 1 year from the close of the year of registration. Right? Year of registration. So 1 year, maybe calendar year or financial year, whatever. But here you have made something
the
in
date.
case of upward charge. From the date of such upward charge. Now how to relate this date of such upward charge? Only this much.
Lord.
Because he has been clarifying, amending everything, but still has not come out with a clear idea. Ministry.
Right.
And this clarification, page 66,
Lordship.
it appears that because of everybody seeking clarification. See the first paragraph, second paragraph. It is brought to the notice of the enterprise, entrepreneurs, general public that so and so have been asking for clarification. So one thing, Mr. Deka, when this Uddam thing has come,
I think with that notification.
which from which date? Tell me.
2020.
20?
26/6/2020. I think so. That is the notification, no, which requires.
26/6/2020.
2020.
Okay.
7 of the.
So from 26/6/2020, one can get registered in Uddam.
Yes,
Udyam. One has.
So they have come on 23.
23.
No,
Yes.
they are already registered under Udyam.
Uddug
UM.
Udyam.
Uddug Adhar.
Udyog Adhar.
Uddug Adhar, they were there. They were small there.
They are small there.
They were small there.
Yes.
Now, after Uddam, you have fetched, they have fetched data, auto-correlated, whatever.
Whatever.
See, after system was put in the portal or whatever, they have fetched the data, they have created this document and issued it. Is there any date of application?
That is not there, my lord. Asani.
No.
Anything there, date of application, Mr. Chaudhary?
There cannot be because it was extended till 30th June 2022. one.
No. Date when you applied.
My application.
Your application.
It is not reflected.
So this, if these data are faced, Mr. Roy,
Lordship.
page 25, this row, 2 row, investment in plant and machinery or equipment. These two, see, one, this enterprise type, medium,
Lordship.
right? Medium. This might have been created also on 23rd January 2021.
Lordship.
Might have been. Or whether they were knowing their status since 2018 or 2019 or recognized and 2019, 2020. If they are recognized in 2018, 19 or 19, 20 as medium, end of the case.
Lordship.
Absolutely. That is the case.
End of the case.
Lordship.
Have you got the idea?
I go
And if that recognition is communicated under 8.4.
8-4, Lordship.
Because
8-4.
without communication, it is nothing.
8-4, end of the case.
Lordship.
Otherwise, you have to find out tell me the meaning of this upward chart.
Upward change.
And Mr. Deka, what kind of work is this?
This is basically the boundary wall for protecting, not a pipeline, a gas center, my lord.
It is not pipeline.
Not pipeline,
No problem.
it is a gas station, my lord. Pumping station.
How big it is?
It will have to have very high security because of the gas and all, perhaps.
Ultimately, my lord, if we go to the specific relief act, my lord, this will be part of an infrastructure project, my lord. Because the tender says, my lord, at page 34, tender document for balanced boundary wall at site development for compressor station. Page 34, my lord. For Northeast Gas Grid Pipeline Project on open domestic so-and-so bidding. Page 34, subject in bold, my lord, tender document for balanced boundary wall and site development for compressor station for Northeast Gas Grid Pipeline Project. So it is a part of the pipeline project.
No, how big is the compressor station?
That, my lord, that I'll have to take instruction, how big it is.
One compressor station, how big it is?
That, my lord,
How much is the cost? We can
It is about
have an idea.
cost of the compressor station, my lord, or the.
No.
cost of the work is, my lord, about, I will,
Any,
Page 40, my lord. Oh, no,
Yes.
40 is the similar work criterion.
say there could be, there could be some benchmark.
Page 40 is the benchmark.
No, this is execution,
No, my lord, the benchmark of the tenderer, whatever.
right? That is their
no, the
qualification criteria.
Yes.
value of the work is not given, sir.
Right, that is why I am trying to find out that in normally PWD case, what is that? SOW or what?
SOR, my lord.
SOR.
Schedule of rates.
So basically a price is fixed.
Tender value,
Sometimes prices are fixed, sometimes it is left open. Sometimes if prices are fixed, then they are required to give percentage basis. my
That
lord.
is an exception. Here, I think it is an exception. Nobody knows.
No, I'll find it out, my lord.
Then it is another. Mr. Roy, you better try to make the effort, otherwise. First of all, whether this gazette notification exists, Mr. Ndeka,
Which notification?
is 92. Because of the FAQs issued later on,
Which notification, my lord?
this 40.1,
Right.
by virtue of which you have included this and
Yes, my lord, that is the PPP policy, my lord.
that is the policy itself.
That is the policy.
Page
Action
30.
plan.
then why this FAQs in 2022? Huh, Mr. You are not aware?
Which one? I'm aware of that.
Then
I'm aware of it.
question number 18,
Yes. Question number 8, the PPP policy itself is clear, my lord, clause 10.
works contractor excluded from the purview of public procurement policy for MSC's order 2011.
That is why I could not make that argument, my lord. Actually, it is not applicable. But having given the benefit, my lord.
Mr. You are clear about it?
Lordship.
Oh, next Wednesday then.
27.
I, Choruri, Senior Counsel Petitioner, SS Roy, CGC, for the respondent number 1 and 5, and Deka for the respondent number 2, RJ Das for the respondent number 4. List the case again on 27. Mr. Roy, CGC shall obtain instruction about the modalities sorry, about the about the date from which a unit registered no as to from when or what date a unit enterprise and an enterprise no unit an enterprise negative. Prior to registration of an enterprise who was registered under the who was previously registered who was having Uddog Aadhaar registration certificate. An enterprise Uddam registration. Uddam registration. An enterprise who was earlier registered, who was issued Uddog Aadhaar registration certificate, comma, is to be treated as medium enterprise on reclassification in terms of the notification dated 26/6/2020 and the notification dated 18/10/2020, read with the clarification dated 28/9/2021, issued by the Ministry of Micro, Small and Medium Enterprises. Full stop. Mr. Roy shall also obtain instruction as regards the date of upward charge, comma, as indicated in the notification dated 18/10/2020. This thing, when he is to be treated, from when he is to be treated.
The interim will continue till then.
Lord, in item 50, Lordship will keep it as a part matter, my lord.
No, it would list it. I'll be there.
27th.
27.
My lord, in item 50, there is
Item number
There is
one,
Motion, yes.
production list item number one.
item 50, there is an interim order, it may be continued.
You file your,
Because status quo order is there. I filed my affidavit.
you have filed your affidavit.
And I have also
So,
taken.
is 50?
50, 50.
50. Okay,
Order dated 38/2020.
affidavit filed,
Might may not come to the record, but
you have filed.
I have given a copy to my.
Yes, I have been served.
Okay, P. Bhumik petitioner and B. Chakraborty and its Central Government Council for Response number 1 and 2.
My lord, I have.
First up, Mr. Chakraborty has submitted that an affidavit in opposition has been filed yesterday
Monday.
on Monday. First up, as the said affidavit, as the affidavit in opposition filed on behalf of the respondent number 1 and 2 is not tagged to the record. Please the case someone someday else with you. Friday, next Friday. Next Friday,
My lord, in.
the interim order. Pass on.
Interim order may be continued.
I have said
My lord, in item number 50, I have the instruction to appear for respondent number 3, my lord.
item number.
50, my lord, 50, my lord. I have the instruction to appear.
Okay, Mr. Yes, wait. Mr.
A.K. Gupta, my lord.
A.K. Gupta, Learned Counsel, has submitted that he has received instruction to appear on behalf of the respondent number 3. First of, as all the respondents have appeared, raised the case in the admission column on Friday.
My lord,
Interim order,
my lord, let it be after at least 10 days, my lord. I have to file my affidavit.
10 days, he needs 10 days.
Let it be on 10.
Mr. So-and-so has prayed for 10 days time to file counter affidavit on behalf of the respondent number 3. The prayer made by so-and-so is allowed. Affidavit to take for 9-10 interim order.
Lordship, 9th, I have a strict matter. Let it be on 11. 11. Maybe, item number 59.
Wait, we are trying to take up a motion. What kind of urgency you have? Hey, it got pinching money. Pinching money. Yes, Devnath.
You are here now. Again, yes. You lost.
Yeah,
We have
again
informed
left, my
Kumar
lord.
Kaur and Devnath. Devnath was here. Now again he has left.
Because something has to be passed in your presence, right? Tomorrow then?
Tomorrow, my lord. Tomorrow, my lord.
Mr. Eskedas for the petitioner. M. Chetia. Learned Junior Government Advocate Assam.
For 2 and 4.
For the respondent number
2 and 4, my lord.
2 and 4 are in attendance. Full stop. Learned Standing Council, Panchayat and Rural Development Department is found today absent on call. Found absent today on call. Full stop. As the Learned Council for the petitioner has expressed urgency, is the case tomorrow. What are you? Yes.
Item number 40, my lord.
You are not there at that point of time.
Yes, my lord. Actually, sorry, my lord.
No, it is not possible.
But only to dispose of the representation, my lord. Representation
It
is
is not possible at 4:40.
because my lord, otherwise, my lord, they have.
Matter was called.
Yes.
You are not there. Somebody is wait for time being. No other matters are taken up, Mr.
Next week, my lord, one date, maybe.
We cannot sit on. Cannot go sitting.
Yes, Wednesday, my lord.
This matter was hard, Lordship, 54.
54 is to be, yes, 54 is to be hard.
Yeah, already hard, Lordship. See what was, Lordship,
Wait, Mr. Yes, tomorrow then. Tomorrow we have less case, na? Tomorrow. We don't have time. Then we are releasing it from part hard
No, Lordship.
and list after 2 months.
My lord, item number 49, my lord.
Tomorrow at 3, again at 3 p.m. tomorrow at Lord. Same was at 3, it was this at 3 p.m. Lord. Otherwise it will not reach, Lord. May not reach.
That is why I put it on part hard, but this matter came up.
Lordship.
So otherwise I was
Yes, Lordship.
finishing all the matters by
Lordship,
3
yes,
o'clock.
Yes, Lord.
Lordship, item number 55, can it be Lordship after?
Tomorrow.
No, item number 55, Lordship, when.
That I have passed the order, mister. Don't ask for that after passing the order.
Item number 49, it is very urgent, my lord.
What?
My lord, we have filed an IA. my
Mazat koi
lord.
thake re.
Item number?
Regarding 49, my lord. 49. I am, my lord, correction for respondent name, my lord. My lord, instead of executive, moreover, my lord, the.
What about 54?
Lordship, tomorrow at same time, Lordship.
Same time.
Lordship.
Due to paucity of time, the case could not be taken up today. List the case tomorrow. Matter will be taken up at 3 o'clock.
Lordship.
3 o'clock.
I said, Dr.